Any mention?
May I please, Your Lordship? Your Lordship, I beg to mention item number 32 to 40, Your Lordship.
Why?
The conducting counsel is out of station due to some
Who's the
personal
conducting
difference. Yes, yes, Your Lordship.
Who's the conducting counsel?
Mr. S.K. Hassan, Your Lordship.
Mr.
S.K. Hassan.
Number 32 to 40?
Yes, Your Lordship.
I will see adjournment. Your objection?
No, my lord. Pertaining to BSc, my lord.
32 to 40?
Yes, Your Lordship.
When you wanted, we have a fixed date, we'll finish them off.
Your Lordship.
Next week?
After 2 weeks, Your Lordship.
30 40 on the request of request is made for adjournment.
No, petitioner, my lord.
Request made to adjourn on behalf of the petitioner due to the absence of the arguing counsel. At least after 2 weeks. Yes.
Deploy.
Please, Your Lordship, I beg to mention item 29, Lordship. I filed a rejoinder on Friday. I'm praying for some time to
For adjournment,
petition, Your Lordship.
Mr. S. Deb submits that they have just received a copy of the rejoinder. He prays that matter be adjourned for 1 week. Very allowed, yes.
Highly obliged, Lordship.
For 1 week, yes.
Please, Lordship. Shall beg to make a mention item 25, Lordship. 25 and 26, Lordship.
24 was linked to. What was being 24? Who's the 24? Oh no, for the 24.
24,
24
Lordship.
and 25.
Yes, Lordship.
24 is Mr. Pathak and 25 is Mr. Paul.
Item number 24, I've been informed, my lord.
You informed them. 24 and 26 is after 2 weeks. He'll be back after 2 weeks, first of all.
After 3 weeks, my lord. 3 weeks.
Why? Now Mr. Bhala is a governor of Manipur. So how can you contempt lie against him now? You take a call 3 weeks, you also take instructions. Or you will close his contempts on the next date. Just inform, be informed. Yes.
Lordship, I'm praying for matter for unlisted tomorrow, Lordship. For unlisted motion tomorrow.
Why was urgency?
Some urgency, Lordship. Please,
What
regarding
urgency?
regarding tender matter, Lordship. FCI. I've been blacklisted, Lordship, and I'm not be able to participate in a tender.
When were you blacklisted?
Lordship, on 26 February 2025, just recently.
The tenders are closing when?
On 8, Lordship. 8 March.
Why are you blacklisted?
What
do you do?
Lordship, I'm a bit handicapped. Lordship.
Two things, debarment and the blacklisting are two things. We've been debarred, blacklisted.
Blacklisted, Lordship.
It's a very serious thing. That you're allowed to represent against the blacklisting.
Lordship will try to satisfy, Lordship.
No, you're not.
I don't have the
you're
brief
not a
right
counsel
now.
Here.
I don't have the brief right now, Lordship.
Because sometimes mention is made, and when the file comes, the facts are different, and the mention we are different when made by local counsel sometimes. Okay, tomorrow.
Tomorrow, highly obliged.
Your Lordship, I beg to mention item 41.
41 is linked to 42? No.
41, Your Lordship.
Who's the other side?
Demon.
For the petition, Your Lordship.
You have no objection?
No objections, Your Lordship.
When?
After 2 weeks, Your Lordship.
Okay. Yes.
Obliged, Your Lordship.
Please, Your Lordship, I beg to mention item 42. I pray for 2 weeks' time.
Why?
I have some personal difficulties, ma'am, today.
What personal difficulty?
I
It
have
will become personally very difficult for me to adjourn matters also. We'll see adjourn, yes, after 1 week.
obliged, ma'am.
Obliged, Your Lordship.
Please, Your Lordship. I beg to make a mention for item number 23, Your Lordship.
23?
Yes, Your Lordship.
Mr. Tiwari is there on the other side.
Yes, Your Lordship.
I was informed.
You've come especially for this matter?
Neither Mr. Subir Sen nor the senior counsel from Bengal, both of them are having difficulties. This is what I was informed. So if that be so, because without, in their absence, certainly, my lord, I can't do the case. So the 1st April was the date, my lord, which was decided. So I agree to that.
When?
My Lord, if it come on the 1st of April, Your Lordship. Because the
Fool's Day.
Yes,
You'll make a fool of this court again.
That is my worry. They should not make fool out of myself.
Okay. Just on
Obliged,
the
Your
request of the council, respondent number
6, Your Lordship.
6 due to unavailability of the arguing senior. This matter on 1st of April.
1st of April.
Yes.
Obliged, Your Lordship.
Your Lordship, I beg to mention item number 31. Your Lordship, the outgoing counsel won't be able to come due to personal difficulties, Your Lordship.
What's the matter about?
Increment, Your Lordship.
Increment. He's gone to Mokorat, Mr. Deb.
Yes, Your Lordship.
Okay, after 1 week.
Last, Your Lordship.
Good hearing.
Item number 1.
Chief, here, this is a case for compensation due to electrocution, Lordship. This is the second round of litigation, Lordship. In the first round of litigation, Lordship, that is at page 37, my Lord has directed to dispose of the representation. That has 37, Lordship. Lordship, 35, Lordship.
What has been complied?
35, Lordship.
35. Yes.
This is direction given to dispose of the representation, Lordship. Now what happened, Lordship, when there was a non-compliance, then I filed contempt petition, then the law officer of the respondent, he assured that it will be in the process of compliance, Lordship.
You have not got even 1 rupee also?
No, Lordship. Now,
But, Mr. S.A. Sheikh, you should notice. Who's appearing for the, where's MS Kolni?
my Lord, my junior colleague, he failed to serve the copy to the, yes, Lordship.
Not accepting.
No, Lordship, because he failed, he could not serve the copy to the,
He fell ill?
he could not serve.
He failed, Lordship.
Oh, he failed?
Yes, he could not serve.
We are accepting behalf of respondent number 1, Lordship.
I'll serve to her.
Yes, I'm here, Mr. Sheikh. You should notice MS NG Shila, senior one advocate with so and so the present on behalf of number 1. Notice to issue to the remaining respondents by service on a standing counsel within 3 days. Yes.
Now, Lordship, there is a private that company that respondent number 4 and 5. I have to take step.
Standing counsel on the
3 and 4 is the standing counsel here. Roji.
no 1, 2.
1 is government,
1,
Lordship.
2, 3.
2, 3, yes, Lordship.
3
MECL.
and
4 and 5 is the company, Lordship. Yes, Lordship. I have to take step.
no? To respond number 2 and 3, notice to author issue, notice to respond 2 and 3 to be served personally to the standing counsel, and for response 4 and 5 steps to be taken within 3 days. But the AD just after 2 weeks. Is
Much obliged, Lordship.
Item number 2.
This is a contempt, my lord. But I'll just draw your lordship's attention to an order passed by your lordship in October.
in a contempt.
Contempt, my lord. My lord, 30th October, your lordship's order.
Yes.
My lord, my learned friend has a submission to make.
Yeah, Lordship, this contempt has taken by the Advocate General, so Lordship, no, we have filed the additional affidavit, so if...
What actually affidavit?
Yes, my lord. I'll just, your lordship has the order dated 30th of October.
Yes.
It reads, my lord, an affidavit has been filed on behalf of the respondent stating that there has been no willful disobedience or violation of the order of this court dated 5th of September 2023, and the department would appoint candidates as and when the requirement arises. Mr. So-and-so, learned counsel for the petitioner, submitted that the affidavit shows a blatant contempt of the order of this court, and as much as the direction as contained is for the respondents to examine the vacancy position in the department and take steps in accordance with law, which appears to have not been done. Now, your lordships kindly have order dated 28th of November. 28th of November.
Yes.
Yes, my lord. It reads, my lord. The learned Advocate General has appeared on behalf of the contemner and has firstly tendered his apology on behalf of the respondents with regards to the contents of the early affidavit, which he submits as due to inadvertence. He prays that he may be allowed to file an additional affidavit to bring on record the vacancy position. Now, my lord, an affidavit has been filed on 16th of December 2024. If your lordships has the affidavit filed by the state, additional affidavit.
Yes.
If your lordship may kindly have para 4.
Yes.
It reads, my lord, that it is humbly submitted that there are 28 sanctioned posts, 28, my lord, for sericulture inspector.
That means the vacant 28 vacant posts as on date.
Yes, my lord.
There are 6. I'll just read.
I don't recollect.
Just
I think only 3.
Read the whole thing.
My lord, it is humbly submitted that there are 28 sanctioned posts for sericulture inspector, reeling foreman, farm manager, and under the Directorate of Sericulture, Weaving, Government of Meghalaya. It is humbly, para 5, it is humbly submitted that out of these 28 sanctioned posts, 50%, 14 posts are to be filled through direct recruitment, and the other 14 posts are to fill through promotion, my lord. Now, para 6, my lord, that is humbly submitted that presently 15 posts out of 28 sanctioned posts are occupied by the candidates, including the 6 petitioners who have been appointed on officiating basis. Officiating basis, 15.
So your function is officiating now. So
Officiating, my
you
lord.
sit down, Ms. Dhamma. Yes. Yes.
Yes, my lord. Now at para 8, my lord,
Yes.
it reads, my lord, that it is humbly submitted that in compliance with the order of this honorable court, the vacancy position in the department was considered at present, and at present, vacancy position in a department is that against the 14 sanctioned posts for direct recruitment. No post is vacant for direct recruitment. Very strange, my lord. Beyond officiating and they're saying there's no vacancy, my lord.
Once that's humbly submitted, presently 15 posts or 20 sanctioned posts are occupied candidates, including 6 petitions upon officiating basis.
On officiating basis.
So they really mean to say these 14 posts are
Vacant.
being filled by promotion?
No, my lord. They are all vacant, my lord. By promotion, there's no candidate at all, my lord. So out of 28 posts, only 15 posts are
They not
occupied.
advertise them at all.
No, my lord. So out of 28 posts, as on today, 15
What was
posts
the
are...
order in the order said to be violated? What are the directions?
My lord, for special recruitment, my lord, to consider the case of the petitioners, my lord. If your lordships kindly have my contempt petition at page 11. Page 11 and exit 2.
Yes.
I'll read from the beginning, my lord, the entire order. Para 1, my lord, the writ petitioners, 6 in number, are before this court seeking direction for consideration of their regularization in service by the respondent. The case as put up by the petitioners are that pursuant to an advertisement inviting applications from candidates for admission into postgraduate diploma in sericulture, the petitioners, after appearing in the written exam and personal interview, were selected to undergo a training. On completion thereof, the petitioners were then appointed on temporary officiating basis to the post of reeling foreman, so on, with a prescribed pay scale. Para 2. It is noted that the appointment order at the footnote, it has been provided that the appointee was requested to apply to the Secretary MPSC as soon as the post against which they were serving was advertised for regularization. It has been contended that the petitioners have been serving since 2010, 12, 14 respectively, and have not been given any consideration for selection and regularization amongst the posts which they are serving. Mr. So-and-so, learned counsel for the petitioner, submits that the posts against which the petitioners were serving are presently lying vacant, and there should be no hindrance on the part of respondents to engage in the process of regularization through the MPSC for accommodating the petitioners by way of special recruitment. In support of his submission, the learned counsel for the petitioners has referred to an order of this court passed in WPC 53 of 2019, which he submits two similarly situated petitioners in the same department. On the orders of this court, the process through MPSC was concluded, and subsequently they were afforded appointment. It is finally submitted that the case being similar situated, in view of the vacancy position in the department, that appropriate orders be issued to direct the respondents to engage in a process for regularizing the petitioners against the vacant post. Note para 5. Having heard the learned counsels for the parties and noted the submissions as also the materials on record, it is a fact that a mandamus cannot be issued to direct the respondents to regularize the service of the petitioner. However, in the present case, the circumstances are such that the writ petitioners were appointed against vacant sanctioned posts and were also afforded regular pay scale along with increments, which has all the trappings of regular employment. The case of the petitioner cannot be said to be absolutely without merit. Also seen the order passed by this court in WPC 53 of 19. In that case, however, it is seen that the department had issued a draft advertisement for regularization of service along with the approved list for special recruitment to the post of weaving inspector, which in action of the respondent, this court, on being approached by the petitioners, had issued directions for conclusion of the process as per the said draft advertisement. Though this case stands on a different footing, however, one fact that this court cannot ignore has to consider is the terms of appointment, especially the footnote in the appointment letter dated so-and-so, which is similar to the other appointment letters. The same, for the sake of convenience, is reproduced below. Now, Your Lordships, yes, page 16, my lord.
Yes.
The column on the right, my lord.
Yes.
You are requested to apply to Secretary MPSC Shillong as soon as the post of the manager, sericulture inspector so-and-so is advertised by MPSC for regularization of your appointment. The present officiating is hereby temporary, and unless you apply to the commission and recommended is for regular appointment to the post, you are liable to be discharged at any time. You are requested to submit the joining report along with the medical fitness certificate of the fitness from government service issued by civil surgeon. The date of joining a person should be intimated in due course. Now, Your Lordships, para 6, at the bottom of this page 16, minute, it is noted that the appointment letter itself, the appointee writ petitioner were requested to apply to the Secretary MPSC as soon as a post was advertised for regularization of the appointment. Looking into the situation of the petitioners, that is no doubt they are not possessing any legally enforceable right to seek regularization to the post, but however, in the consideration view of this court, the case deserves some consideration by the respondents in view of the footnote that has appeared in the respective appointment letter. Accordingly, this writ dispose of at the direction that respondents consider the case of the petitioner by looking into the vacancy position in the department and to take steps in accordance with law to consider the regularization. Now, my lord, in this additional affidavit that they have filed now, they are saying there is no vacancy, which is strange. They themselves say that we are on officiating, and on the other hand, they say there is no vacancy, my lord.
Yes.
Lordship, kindly come to para 7 of the additional affidavit.
You ready with the matter?
No, Lordship, as per the, I'm just reading as per the
As
additional
per the
paragraph of 7.
No, this won't do, because you see the appointment of these people is not ad hoc. It's like it's officiating after they were sent for post graduation. So the case is different from other 2007 cutoff. So this does not really apply. Anyway, who's arguing counsel? Mr. Kharonlang?
No, Lordship, Advocate General.
You take heard the counsel petition at some length. It is noted some length of the contents of the additional affidavit have been noted by this court, wherein it has been stated that there are no, for direct recruitment, that there are no vacancies at present for direct recruitment stuff. General Advocate General appearing for the, who's not present today, appearing for the alleged contemptor, is directed to obtain clarifications on this point. That's up to 2 weeks. Yes.
Much obliged.
It's not possible if they are serving against his direct recruitment post. How can he say there's no vacancy?
Item number 3.
But our affidavit will be filing in the course of the day, madam.
Last chance.
Yes, madam. We are filing it today.
They give you copy?
No, Lord, I'll, after signature is done, I'll.
After some time.
Okay, Lordship.
Yes.
Or are we filing it today?
We'll take off some time, Mr. Parshaji. I'm tired of this.
my lord,
We'll take off some time.
once-
Why? Before I rise, if the matter is not filed, then we'll impose costs.
My lord, only difficulty, my lord, only the signature, my
You
lord.
have not served them also?
So, copy I'll serve it to them, my lord. Copy I'll serve it to them only for the signature, my lord.
Mr. Kibash submits that the affiliate will file the cost of the just after 2 weeks for rejoinder of any. Otherwise, this course of the day business sometimes.
No, no, my lord, we are filing it. Only the signature is the problem. my lord.
Item number 4.
In this matter, we won't be filing rejoinder, my lord. This is a selection matter, my lord.
Who's that outside?
Dr. Mozika is there, my lord. Your lordships
He's on
can.
the station.
No, Your Lordship. He's
I
on
think
legs, Your
he's
Lordship.
on his legs.
He's on leave on his legs.
On his
He's on
legs,
his
my lord.
legs, Your Lordship.
Oh.
So we have it next week, my lord, for hearing.
Regarding which, what's
This
the matter
this
about?
is selection, my lord. That hypertension case, my lord. He was with
Assam Rifles.
Assam Rifles, my lord. Next week.
Mr. Philomen submits that rejoinder with this for hearing on so and so.
Next week. My lord.
5.
What to do this case?
Lordship, as per the last report, Lordship, they are yet to
It's
get
still
the
under
details,
investigation, my lord. It will take some time, my lord.
Also, my lord, the bank has not come with any response, my lord, till date. So that is one aspect, my lordship.
You file affidavit, correct?
My lord may dispose this case with direction to expedite the
Because this case is very difficult,
Yes.
Mr. Chanda.
My lord.
Because what has happened is that it was a valid transaction on the part of the petitioner, whatever one transaction, because it was from her number, the OTP was received. Only the thing is that the recipient, she was scammed. That's all.
She was. Yes. Admittedly, my lord. Yes, my lord. My lord, I may be allowed to take give instructions, my lord. 1 week. It may be fixed.
Only thing is bank you. There's no way you can.
Lord, there was deduction, then the money came back, man.
No, that,
again, my lord.
that they explained.
my lord.
Explain that.
That is shadow. We've already clarified.
Yes.
That's as per the circular.
Let's take the Mr. Ensign submits that the investigation is still underway. And that further instructions are awaited. What's the progress? It's a multi-state.
My lord,
They've apprehended the person. The person from
notice
the
has been served, my lord.
The person from who's registered as the owner of that. I mean of that number registered. He's been apprehended.
My lord, the notice has been served to him, my lord. He was
Served to him on 41A.
Yes, we have sent it through SP, my lord, of that particular district. So, my lord, he's
still not appeared, my lord. He's still not appeared, my lord.
Supposed to appear, my
The
lord.
owner of the phone won't know anything, but the number
my lord.
he's from Bihar.
Bihar.
And the call is made from Haryana.
Haryana.
Then and you received it here. The take down business and call learned common advocate. He please will have to obtain some instructions. Mr. Marpan, anything to say?
The only thing is we're cooperating in investigation.
Mr. S. Marpan has reiterated submissions that the bank is cooperating with instructions and will abide by any directions of the investigating agencies. List after 2 weeks. Otherwise,
Item number 6.
it's happening everywhere.
My lord. Everywhere, my lord.
Lordship, I'm required to file my rejoinder, Lordship. Lordship, there's some personal difficulty on the
You
part of
haven't
the...
filed it?
No, Lordship. There's
Then no more rejoinder. That's
Lordship,
over.
there's some personal difficulties on part of the petitioners, Lordship. One is from Agartala and one is from Nagaland.
Final opportunity was granted. Will this is for hearing? You can file it in the meantime.
In the meantime, I'll file.
Otherwise, it's this after 2 weeks.
After 4 weeks, Lordship.
4 weeks.
After 4 weeks.
Agartala is very far.
Lordship, we have to
They can
get
swear it there and send it by courier.
3 weeks, Lordship.
Yes. This rejoinder, the last opportunity was granted on 12/2/2025. The rejoinder is still you're on board. Stop in interest of justice. List the matter for hearing after 3 weeks. In interest of justice, the rejoinder may be filed in the intervening period.
Obliged.
7.
Please, Your Lordship. I've received the affidavit by the respondent number 1 to 6. You would require to file a rejoinder, Your Lordship.
What about number 7? You appeal number 7?
Respondent number 8, Your Lordship.
You're filing affidavit?
No, Your Lordship. Today we filed for power, Your Lordship.
Are you filing affidavit or not?
Not yet, Your Lordship. We pray for
Are you filing or not?
Yes, Your Lordship.
Say that. It's a family pension matter.
Lordship, it's that where the wrong information was given to by the pensioner. So I'm the wife.
And who's this one number 7 and 8?
7 is a bank. It's a state bank.
Vaishali, Bihar.
Yes.
They've been served.
They've been served. I filed
Correct
the
address.
correct address.
You file affidavit service
Affidavit
also?
already, sir. Already filed.
Though it's noted that respondent number 7 since been served, there's no appearance on their behalf. Stop. Your name?
Afshala, Your Lordship.
Ms. Afshala, Learned Counsel for respondent 8, prays for further time to file affidavit. Stop. Next from Ms. Esmarapan also, please have been allowed to file affidavit to the rejoinders affidavit filed by respondents 1 to
1 to 6.
All prayers allowed just after 3 weeks. Yes.
Lordship.
For rejoinder and for appearance of respondent number 8. Affidavit of respondent number 8.
Item number 8.
Lord, here they filed an application under 226(3), my lord, for the respondent, my lord, for vacation. I'm praying for 2 weeks' time, my lord, to file my reply.
Gone to 33.
Your Lordship, I pray if this matter may be taken up at the end of the vote, Your
Let
Lordship.
them come. Argue it if there's some merit. Yes, if there's no other.
My lord, like I said earlier, my lord, here the order which they had passed subsequently, which is not in our knowledge, but that order, my lord, is devoid of any reasoning.
So that let's see. That
Let it come, Your Lordship.
9.
Much obliged.
it comes sometime.
My lord, this matter, according to me, the matter is not yet infructuous.
Why?
Though the respondents are contending, my lord. The two issues are here.
Given the matter involving election, Mr. Chandra, so sorry you won't attend it.
My lord. Two petitioners are here. One is a candidate. His nomination paper was rejected.
Then
He has a remedy for tribunal, which he is not willing. Now, the second issue is, my lord.
willing.
My lord, yes. Second issue is the petition number 1 and 2. Their names as a voter list, from the voter list were deleted. So that they challenge that deletion of the voter list. Now, under the Water Act, the decision of the executive committee with regard to voter list is final. They cannot go to tribunal, my lord. And their names, their mother name, their sisters, brother, sisters' name are in the voter list. Whereas these two gentlemen were excluded. So that is the issue only.
Then you withdraw and file afresh.
New cause of action.
New cause of action.
My lord,
Yes.
it is.
So the election is already over. Mr. Chandra, so
But with regard to
the cause that the matter has not been rendered infructuous fully, as because respondents petition number 2 and 3.
Petitioner number 2.
Petitioners number 2 is challenging the.
My lord, petition number 1 is challenging, both of them are challenging the deletion of their name from the voter list, and petition number 1 is challenging the rejection of his nomination papers. So we have taken both the grounds in the petition, in fact.
Yes, though both the grounds of rejection, nomination, and deletion of voter list has been taken in the concerned opinion of this court. Both the matters can be taken up by election tribunal as it concerns election of Varadar, which has recently been concluded. You can take it up together. Then, if the election tribunal finds that your nomination rejected just because of deletion,
yes, deletion,
that will be corrected. The Presidential liberty to avail of alternate remedy. Yes.
My lord,
matter stands closed. We're not going to cloud the matter.
My lord, liberty given to them to approach before this court.
Yes, yes.
Because they cannot go to the tribunal with regard to deletion.
Take alternate remedy.
Yes,
See, the thing is conjoined, Mr. Chandra. So, even if they can't go, suppose it's found that your nomination is rejected wrongly, it relates directly to your deletion of the name electoral roll. So,
my lord, with regard to my humble prayer is, my lord, the tribunal has no right to decide with regard to deletion of the voter list. My lord, the voter Wahatar is very clear. Section 16 of the Wahatar Act. Might just take a lordship time. Lordship may not mind for troubling you. But
the thing is,
it is there, my lord. Wahatar Act, Section 6, my lord, kindly see.
Page
My lord, in my petition, Lordship, my averment.
No, where's section?
My lord, may kindly see, I have cited the act. The act is my lord. Section 6, my lord. May I come to subsection 4, 2T. It says, any person whose name does not appear in the electoral roll, thus publish, or any person having any objection to make with respect to the eligibility or otherwise of any voter whose name appears in the
Why
electoral
is
roll.
final?
My lordship, kindly see E.
6F.
My lord, 6E, my lord. On receipt of such a petition, the Secretary Executive Committee shall notify the date and time when such petition objection shall be heard by the Executive Committee, whose decision the
You
matter
file
is
objection for the committee.
Oh, my lord, petition was filed. They heard it, my lord.
Then you file a fresh petition with regard to your direction nomination. Then you file a fresh one. Petitioners also permitted to a liberty to file fresh proceedings if cause action still remains.
Right.
Item number 10.
Well, we won't mix up the
Yes,
rejection and the petition.
This matter, a political appeal is pending before the district council, my lord.
No, but then who said it's fructuous?
Uh,
Where's Mr. Philemon Nombri?
The matter is not infructuous as such, my lord. We have challenged those impugned letters. The letters
What political appeal is pending?
Well, political appeal against, my lord, that an order was passed, in fact, by the district council itself, staying the earlier notification issued by the CM of Milim. Now, my lord, in the month of January, on the 15th of January last year, I mean, this year itself, my lord, another letter was issued by the KHDC that you conduct a public hearing. And then, my lord, a public hearing was also conducted, but my lord, we had come before this honourable court on the same day. Some interim orders were passed. Now, my lord, they say the matter has become infructuous, then, my lord, the matter may be fixed for hearing, then, my lord, we'll argue the matter.
What's there to hear then?
Nothing survives.
There's
Lord.
nothing
The
survives.
interim
My
order
lord.
is as good as a final order, my lord.
Well, in that case, let the political appeal be decided then, my lord. If
Now, this is which locality?
This is Langtron.
Norma.
It's been bifurcated.
No, my lord.
There is a prayer for.
What is a prayer for creation of a separate locality?
Separate village, full-fledged village. And the same initiated some action, holding meeting, holding this and that to hear the public. Then being aggrieved by that direction of the same, political appeal was filed in the district council on the same course of action, same matter. Thereafter, when there was change of an executive member in charge Ilaka, the next executive member was unaware about this political appeal, and on a prayer of the private respondent, the EM in charge Ilaka directed holding of a public meeting.
Okay.
Then, according to us, according to me also as a counsel for the district council, it could not have been done. So there was some order by this court saying that it should not be given effect to. Now, public meeting has been held, everything has been carried out. I say that, he also will say the same thing. Let the political appeal be decided, and the order passed by the single judge of this honorable court be made absolute.
Well,
I think that will be the best course of action.
Yes.
We all agree on the same page.
Where's the single judge order?
There's Miss Case 1 of 2025.
23rd January.
Was the vacation bench?
Vacation bench.
Vacation bench.
Yes. Miss Case.
I think so.
You don't file affidavit, correct?
Not required. This will cut short the entire issue.
Yes.
We thought of recalling, but it was too late in the day.
Okay. In the instant matter, the learned senior special counsel, Mr. Vijayakinta, has apprised the court about the correct present situation prevailing. Top. He has submitted that the impugned order for holding public hearing. Where is that?
It's at page 42, my lord.
The impugned
40 and 42, there are two orders.
impugned order 40.
Page 40 and page 42.
The impugned order dated. The impugned orders dated 15 January 2025 and 16 January 2025 with regard to the public hearing at Nongrumbal Imkra were passed due to the executive member in charge not being informed about the tendency of a political appeal with regard to the same matter. He further submits, the senior counsel submits that justice would be served if the political appeal would first be disposed of, allowing all the parties to put forth their respective views or submissions. Stop. Mr. K.C.H. Gautam, appearing for the writ petitioners, also does not have any objection to the suggestions as made by the counsel. However, has prayed that as the interim order dated
23rd January.
Interim order dated
23rd January.
25th,
23rd.
23/1/2025, wherein this aspect has been in consideration, the same can be made final and the matter be disposed of. Mr. Phenomenambri, appearing for response number
5 and 6.
5 and 6 and number 4. Response 4, Mr. Arupar number 4 and Mr. Phenomenambri for 5 and 6 also concur to the suggestions as forwarded before this court. Stop. On hearing the counsel to the party, the examination of the order dated 23/1/2025, especially in consideration of submissions made by the learned Senate, learned special counsel on behalf of the KHDC, this matter is disposed of with the direction that the pending political appeal be disposed of first before any further action is taken on the meeting that has been concluded and held on the 5th of
I'm sorry,
when which date was the public hearing held?
On the 23rd, my lord, the same day I came before this court.
23/1/2025. With the above as next matter as ordered above, the matter stands disposal.
One correction, but somewhere it has come as Nongrim Darbar. It is Limekra Darbar.
Oh, not good.
Chnong Pullul.
There's a clarity.
And the locality is Nongrimba.
No, I didn't see it.
That's no issue.
Item 11.
Good evening.
Mr. Kanta in this matter also.
What is this? Lordship, because of the elections, I could not get proper instruction, meaning that I could not file the affidavit on time. I seek 4 weeks' time, Your Lordship.
Mr. V. Kanta today on behalf of the respondents number. Mr. Sten's on leave.
Yes, Your Lordship.
1 to 4.
1 to 4.
Response allowed further 3 weeks time to obtain instruction to file affidavit. Notice is complete on the 5 and 6.
We yet to receive the status
Yes,
report, Your
an office note
Lordship.
indicates that 5 and 6 have since been served. Police is a matter of 3 weeks or 2 weeks?
4 weeks, Your Lordship.
After 4 weeks for affidavit and for appearance of respondents 5 and 6.
Much obliged.
Yes.
20.
We'll do the other orders first because okay, it's still
Item 20.
Your Lordship, I'm appearing on behalf of respondent number 3, that is NHIDC.
where's the petitioner? What instructions do you have?
Your Lordship, we're still awaiting instructions regarding this matter, Your Lordship.
Where's Dr. Mozika?
He's on next, Your Lordship.
Which court?
For court number 3, Your Lordship.
Another PS for the petitioner. Stop MSK Goring. Next part also submits that no instruction received this matter for 1 week. What instruction is?
Much obliged, Lordship.
21.
Yes.
Your Lordship, can I take up after sometimes my senior colleagues having...
Who's your senior colleague?
My Mr. HR Notel.
You declare the result?
No, Your Lordship. So far to my knowledge, the entire possession of the ballot box is with the KCTC.
Well, we have taken steps as per Your Lordship's directions.
Fine, then. Second appeared last time.
Come on.
Some of the parties that. Are you filing affidavit or not?
Yes, sir. Fine.
You file it then first.
Yes, sir.
This is matter up to 1 week. Affidavit to be on board by the next date. 1 week moving indifference.
Lordship, I have received copy of the file today.
The affidavit?
Yes.
Oh, Mr. Nath has come. Yes. Where's the affidavit? It's not been filed?
Today itself, my lord, in the morning it's been filed.
So when do you want it?
My lord, we'll have a short hearing, my lord.
After 1 week, yes. Mr. HR Nath submits the affidavit, will be filed in the course of the day. It's after 1 week for division hearing.
Insofar the direction of this Honorable Court, the election committee had hand over the ballot box, everything with us, and we'll hear.
It is noted, it is further noted as per the directions contained order dated. That time when the matter was moved, 18 to the ballot box in the custody of the district council.
My lord, respondent number 2 has, I think, notice has to be issued, my lord.
Number 2 is whom?
Election committee, my lord.
Not necessary.
Actually, they had given a report. It's placed on top of the ballot box. That will be self-explanatory.
Of your HIMA?
Yes, Your Lordship.
Because
they are independent body.
Oh, yes, then that
independent body
notice
constituted.
to issue to respond number 2 also. Can you serve personal notice? Because after 1 week the matters come, they won't be served.
I'll take necessary steps, Your Lordship.
Yes,
By dusty service?
Necessary steps to be taken for personal service if necessary. Just after 1 week. Religious matter.
Yes, ma'am.
22.
Obliged.
Yeah.
May, please, Your Lordship.
Yes.
This is with regard to freezing of the bank account, my lord.
Yes.
And as per this honorable court's order, on the last occasion, my lord, we have taken dusty service and the affidavit is also been part of the record, my lord. It appears that nobody has appeared from the respondent number 4, who is the bank, my lord. And today has been fixed for passing the interim order, my lord.
Where's the bank? They've been served.
Bank we have taken. Yes, it's been served. Affidavit has been sworn in.
Should we file affidavit on 28th?
An affidavit indicating the factum of service upon the respondent number 4 has been filed by the petitioner. But however, there is no representation on its behalf. Others parties have taken steps. 1, 2, 3.
Other parties steps. No, my lord. Only for interim, my lord. Notice was, my lord, directed to be taken through dusty service to respondent number 4, my lord.
But you're not taking steps for other ones.
There's some confusion with the order, Lordship.
Why?
Lordship, we can take steps today, Lordship.
Yes. Oh, Mr. Fukan, there's some Bhuya, sorry. There's some slight mistake, yes. It is noted that due to inadvertence, court has not issued notice to the other remaining respondents. We'll take it after 1 week then for at least notice.
May I pray for interim? Because within that time, my lord, 20 lakh, 25,000 that has been freezed from July, my lord. That
no, let
should
notice
be stayed,
issue
my
to
lord.
the let notice issue to the remaining respondents also by receipt AD or by personal service. A miscase of interim.
There's no miscase.
Miscase, okay. There's no miscase. Some case you file miscase, some case you don't.
There's a prayer in the main petition.
Huh?
Interim prayer
It is in interim prayer is in the writ petition itself, my lord.
Yes. Mr. Bhuya today has first submitted that as the matter has been fixed for consideration of the interim prayer and as grave hardship has been caused to the dealership on account of the freezing of the account, freezing of the amount of rupees 20,25,000 from the current account of the writ petitioner. The interference of the court is required to unfreeze the same. Stop. What you said, the freezing is without jurisdiction. Why?
Yes, my lord. That is been without following, my lord, the provisions of law, wherein after freezing the local court has to be informed, and even
where have you noted that? Where have you stated that in your petition?
A paragraph 28, my lord.
Yes, submitted by Mr. Bhuya that the concerned police officer or that respondent that respondent number 1, correct?
Yes, yes.
Yes, has not informed the jurisdictional magistrate about the freezing of the amount of rupees 20,25,000 from the current of the petitioner company. The same he submits in violation of the provisions of section 106 bracket 3 of the BNSS, which vitiates the entire process of freezing the amount. So, further, it is submitted that there was no notice. No notice was issued to you regarding freezing.
No notice, my
No
lord.
notice was issued for freezing of the said amount, and that the pressure company, if this court allows the unfreezing, is ready to execute a bond for security of the same. So, stop. Next paragraph. Though the respondent number 4 has been served. Record me, no appearance of no but number 4 has been served, no appearance of the you can't let out of me. Stop. It is noted that though respondent number 4 has been served, there's no appearance on his behalf today. And the same has been served with a stop. Accordingly, it is directed that the amount so frozen shall be released by the. And accordingly, on hearing submission to the petitioner, a prima facie case has been made out for passing interim orders at this stage. It is therefore directed that the respondent number 4 shall unfreeze the said amount, subject to the furnishing of indemnity bond by the petitioner company within a period of 1 week from today. Yes.
Deeply obliged. Deeply obliged.
Item 12.
Orders. You have new other submissions to make?
No, Lords. I think a lot has already been argued.
A lot is understatement.
In any case, they don't have a further right of reply. There can't be reply of the reply. The right of reply is only mine.
In the interest of justice, anything can happen.
Well, then in that case, maybe then
unending
reply of the reply, and of that also there is further response, and then the cycle will go on, never ending. Now, my lord.
One second. Last date was when was the matter taken up?
The last date?
26th. Wednesday.
Excuse me.
Now, my lord, very attentively, my lord, I heard the submissions of the respondents, both of the learned counsel of the commission as well as of the public utilities. Now, my lord, there are three major parts, as I have seen and understood. There are three major parts of their submissions. Namely, number one, the maintainability of the writ petition. Number two, the orders and the judgments of this very honorable court, which they say have decided the issue practically. Nothing survives in the case. Issue is decided by this honorable court. And number three, what learned counsel, my lord, appearing for the commission called the fulcrum of the case, namely the scope of section 93 of the Electricity Act. These are the three major parts. Now, so far as, my lord, the maintainability of the writ petition is concerned, the maintainability issue itself, my lord, has got three components. Number one, having participated in a proceeding before the commission, this was one of the arguments on maintainability, that we participated in a proceeding before the commission, we were there before the commission, now it does not lie on us to turn around and challenge the very jurisdiction of the commission. One. Number two, the suppression of material fact. And number three, the doctrine of exhaustion of alternative remedy. The argument was alternative remedy is there is an appellate forum, we ought to have gone before the appellate forum. So now, my lord, to begin with, I will deal with the maintainability of the writ petition itself, the arguments which were made by the respondents. I will deal with the orders and judgment of this honorable court touching upon this issue, as well as what learned counsel appearing for the commission called the fulcrum of the case at a later stage of my reply. I'll deal with both. But now to begin with the maintainability of the writ petition. Now, the first argument is that having participated in a proceeding before the commission, we can't turn around and challenge the very jurisdiction itself. Now, my lord, the details, the relevant facts as to how we were there before the commission in this very case are there, my lord, in the order of the commission itself. Let us just recall some of the relevant features of those very facts. Namely, number one, the tariff order, my lord, both the order of the tariff order which is impugned as well as the order of 23rd of August 2024. No, sorry, that is not. The tariff order, my lord, which was recalled by 23rd August 2024 order. So the tariff order which was recalled, that tariff order, my lord, was signed by none other than the judicial member.
Yes.
Of course, conveniently they call it the member law, but the gentleman, my lord, the member of the commission happened to be the retired district and session judge.
Yes.
Mr. Soni, my lord, is the retired district and session judge. He is member, either call him law or you call him judicial, but my lord, he is judicial member. Along with the chairperson, my lord, he heard the matter, but only Mr. Soni signed it because chairperson had retired in the meantime. So, once the order was signed by Mr. Soni, order was issued, being aggrieved, the public utilities approached the High Court. The public utilities came.
That was in June when he first signed it singly.
Yes.
Yes, fine. Yeah.
So that is how, my lord, that is the trigger. That is how, my lord, that is how the case begins. So the public utilities being aggrieved by the order signed by the judicial member came before the honorable court. They did not approach the APTEL. They did not go before the appellate tribunal. They came before the honorable court. Para 2 of that very order of the commission says so very clearly. Now, the ground was obviously that the chairman and the member law heard the matter, but only member law signed it. So, which violates Regulation 18, Sub-Regulation 3 of the regulation, which provides for signing of all the members who hear. That very principle is violated. Second stage is the Honorable Court, this very Honorable High Court, stayed the tariff order. There was an interim order dated 25th of June 2024 on the writ petition of the public utilities. Thirdly, my lord, subsequently the counsel for the commission informed the Honorable Court that the commission is ready to re-examine the matter. On this, my lord, the public utilities prayed for withdrawal of the writ petition. When in a pending writ petition, the commission informed the Honorable Court that we are willing to re-examine the matter, the public utilities prayed for withdrawal of their writ petition. The Honorable Court allowed public utilities to withdraw their writ petition and to re-agitate the matter afresh before the commission. Thereafter, my lord, the public utilities filed 6 interlocutory applications before the commission with a prayer for recall of the tariff order that was issued by Mr. Soni. So, my lord, let us see. They are the active players. We are there outside the ring. It is they who are, my lord, aggrieved and they are agitating the matter. So, public utilities filed 6 interlocutory applications. And then, my lord, on the interlocutory application of public utilities, the commission issued notice for hearing because commission wanted to re-examine the matter. Association, this Barney Hart Association, the petitioner individually did not approach the Honorable Court at all. The umbrella organization, Barney Hart Association, came before the Honorable Court in a writ petition and challenged the notice before the Honorable High Court on the ground that commission has no jurisdiction. So, certainly not by the petitioner, but by an organization, this was challenged, that commission has no jurisdiction to re-examine the matter and notice was questioned. Now, my lord, the Honorable High Court disposed of the writ petition of the Barney Hart Industrial Association, asking it to raise its objection before the commission. Whatever objection you have, you go and raise before the commission. Now, my lord, this is permissible. Permissible because the law is well settled that even the issue of jurisdiction can be raised before the authority as to whether the authority has a jurisdiction to re-examine the matter. So, my lord, on the order of the Honorable High Court that the umbrella organization, if it is aggrieved by such a situation, can very well raise its objection, my lord, the writ petition was closed. It was withdrawn, closed, whatever it is. Below, all the details are there in the order of the commission. My lord will find for paragraph 2 to paragraph 9. All these sequence of events are there. Then, my lord, association appeared before the commission and raised the issue of jurisdiction. So, my lord, therefore, there is no question of petitioner submitting itself to the jurisdiction of the commission.
Okay.
The circumstances were such where there was no other way but to appear before the commission and to raise the objection on the issue of jurisdiction. So, the question of doctrine of waiver being applied does not even arise in the present case. And, my lord, most importantly, collective right and individual right are two different things. In a present proceeding, my lord, the writ petitioner is seeking the enforcement of its fundamental and the legal rights. I don't know, my lord, so far as Barney Hart Association is concerned, it may be an umbrella organization, but it was rightly submitted by the learned counsel of the commission, which individual right, which legal right, which fundamental right of the umbrella organization has been violated. This question can be raised, but it is not for me to answer this question, because I am here, my lord, for the writ petitioner. I am here seeking the enforcement of my legal and the fundamental right before the Honorable Court. So, my lord, doctrine of waiver doesn't come into play. Let us be very clear about it. Now, the second argument on the maintainability of the writ petition is there is an alternative remedy of appeal under section 111, a remedy of appeal. Now, my lord, for once again, my lord, each time we look at the provision, we are wiser. Look at section 111 again. What is the scope of the appeal?
Once before we proceed, Mr. Thapa, you said you make alternate arrangements. You read the matter today. Because that time was undertaking you gave, you said that we have the hearing, like notwithstanding Mr. Paul's difficulty. No, you said notwithstanding any arrangement will be made for. Because we don't want to keep this matter just hanging like this.
Only as we had already submitted, Mr. Paul would like to supplement his.
I mean, you said you'll make alternate arrangement. I thought that you had come ready with the matter today to make your. Because whatever Mr. Tiwari has covered everything. I think there's no scope even,
My Lord, let us not underestimate the legal acumen of Mr. Paul.
I think that regarding the.
But Mr. Paul had one advantage, a unique advantage, my Lord, which certainly I do not enjoy. He appeared before the commission and argued the case.
He appeared with commission?
He does. Yes. He argued the case before commission. And various issues he had raised over there.
It's just a concern of the court that, we don't want to keep
I understand.
We want to keep this matter hanging fire for, because we've heard it for. Usually we don't, this court doesn't hear matters.
In any case, my Lord, so much of submissions have been made that I will have to, whatever I am arguing today or whatever I argued earlier, I will, my Lord, submit a written submission. I will jot down all the points.
Just bullet, I don't want an arguments. I just want the bullet points only.
The bullet points itself, my Lord, will be at least.
So once written arguments are given, you have to go through all that.
But
and what happened?
I will give the bullet points.
25 decisions.
I'll give the bullet points. But my Lord, my only fear is the way judgments were placed before the Honorable Court, relevant, irrelevant, all kind of, my Lord, paragraphs which have no relevance in the case. That creates, my Lord, great degree of confusion. Be that as it may, now, my Lord, I was on the alternative remedy. Now, alternative remedy, my Lord, 111. Let us look, my Lord, into the language of section 111. Any person aggrieved by an order made by an adjudicating officer under this act. Under this act is which act, my Lord, I ask myself? Act of 2003. Any person aggrieved by an order made by an adjudicating officer under this act or an order made by the appropriate commission under this act may prefer an appeal to the appellate tribunal for electricity. So, my Lord, it is an order of the commission under this act. I ask myself, my Lord, whether the order of recall was an order under the provisions of the 2003 Electricity Act. That is an issue, my Lord, which is disturbing all of us. And I am looking for an answer. I don't know. I am not sure. I do not know under which provision of law of the Electricity Act this very order of recall was issued by the commission. The inherent power is under the regulation. I will touch upon that scope of inherent power also. But point to be noted is, my Lord, the inherent power, ordinarily, my Lord, the inherent power is always, my Lord, indicated in a substantive portion of the law. It is not there in the act itself. Act speaks of power of review. By way of regulation, they have brought in this inherent power. Section 111 talks about order made under this act.
Okay. Yes.
And section 94, subsection F, speaks of, my Lord, power of review alone. There is no if and but. Section 94F, Lordship may have a look. Powers of appropriate commission.
Yes.
94F, reviewing its decisions, direction and orders. And we all know the scope of the power of review. Then, my Lord, secondly, so my submission is the remedy which is prima facie, which is there, so-called remedy of appeal under section 111, the order itself, my Lord, which is impugned before my Lord, is not an appealable order. It is beyond the scope of the appeal under section 111 of the Electricity Act, because the impugned order is not an order made under the provisions of Electricity Act 2003. That's my submission.
Okay.
Secondly, inherent powers conferred on the Commission under Regulation 26 does not envisage vesting of power of recall and rehearing on the Commission. The inherent power under Section 26 does not envisage vesting of power of recall or rehearing on the commission. Let us have a look at, my lord, regulation 26 of the regulation. Language is very interesting, my lord. My lord, may have a look at page 45 of the paper book, writ petition.
26 is, sir.
Writ petition 9, WPC 9 of 2025.
You're talking about this state regulatory
Yes,
commission regulation, correct? 2007?
Yes. It is MSERC Conduct of Business Regulation 2007. Regulation 26, which speaks of inherent powers of the commission.
Yes.
Page 45 of the paper book.
It's here in the
yes
record.
My lord, may I have a look at our writ petition?
Yes.
Very well. Regulation 26, sub-regulation 1. Nothing in these regulations shall be construed as barring the commission. Nothing in these regulations, my lord. It is not nothing in the Act of 2003. Nothing in these regulations shall be construed as barring the commission from exercising its power under the Act. The power is to be exercised under the Act. That is, the provisions of the regulation will not bar the commission from exercising its power under the Act, for which provisions have not been made or have been made inadequately in order to subserve the spirit of the Act. So nothing in the regulation will prevent from commission from exercising its power under the Act for which provisions have not been made. Now, my lord, provisions have not been made under the Act. This is the only reading. That means regulation is trying to say that if Act does not give you the power, Regulation 26 is giving you the power to do what is not envisaged in the Act. It's quite an amazing, my lord. Regulation overriding the substantive provisions of the Act itself.
It's not under challenge.
My lord, it may not be under challenge, it has to be construed harmoniously. That is all. I am not talking about reading down the regulation. The doctrine of harmonious construction will come into play. My lord will construe it harmoniously. My lord will read it in a manner so as to avoid conflict between the regulation and the substantive provisions of 2003. Then, my lord, second.
Yes.
Sub-regulation 2 says, if the commission is satisfied that there are genuine difficulties in the implementation of any of the provisions of these regulations, it may relax the provisions to such extent and subject to such conditions as it may by reasoned orders decide. I have no quarrel with this. Under the provisions of the regulation, if difficulties arise, you exercise those inherent powers.
All is there. Yes.
But, my lord, the sub-regulation 1.
Removal of difficulties clause, yes.
So, my lord, sub-regulation 1 doesn't give the power of recall.
You have a quarrel with the, you say that it cannot have an overriding at all.
It cannot.
So we have to ignore it. So you read it, you did conjunction with
naturally.
111. That means that you have to put in the shadows.
That's it. That's it.
Okay, that's a submission. I mean,
that's
yes,
a submission.
We'll have to examine that.
Yes,
it's a new dimension you put now to the case.
My lord, inherent lack of jurisdiction, I argued.
Yes, inherent lack of jurisdiction is it is.
That is why inherent lack of jurisdiction comes in.
Yes. Anyway,
I will thereafter touch upon exceeding the jurisdiction also, and I will demonstrate it is very much within the purview of the writ of certiorari. So, my lord, the inherent power envisaged in regulation 26 does not carry within its purview the power of recall. This is my submission, and it is the order of recall.
Cannot vest in the
yes,
in the commission.
And the order of recall is not appealable under section 111 of the Electricity Act of 2003. Then thirdly, my lord, all the judgments
yes,
all the judgments that were cited before this honorable court are in respect of the inherent powers of the court and tribunal. Specifically, two words have been used: court and tribunal, not the inherent powers of the commission. And commission, my lord, is a statutory body. Commission is a statutory body. Section 95 of the Electricity Act 2003 gives commission the trappings of civil court in a very, very limited context, namely in the matter of forgery, etc. That's all. Perjury, in the matter of perjury. In a very, very limited and narrow context, my lord, the trappings of civil court it enjoys. The commission is a statutory body. If it is the statutory body, there is no presumption of the inherent powers. I press into service, my lord, the three judgments I had cited earlier, including Hira's case. Hira's case, Supreme Court judgment and two division benches.
Yes.
I had given those citations in my write-up. In the bullet points, I will indicate that. So, my lord, I am not wasting my lord's time in again taking my lords back to those very judgments which I had referred to earlier.
Yes.
Then, my lord, the Supreme Court judgment in the Greater Noida Authority case, that is 2024 6 SCC 767. Anyway, it is there in the compilation. Yes. It's in the compilation. I will. My lord, the Greater Noida Authority case is an authority on the inherent powers of the court and tribunal. It is not an authority on the subject as to whether a statutory body has inherent powers. This is my submission on Greater Noida. Because Greater Noida, very copiously it was referred to. Everywhere commission and tribunal and court. Yes, we all know court has inherent powers. My lord has got plenary powers. Shivdan Singh versus State of Punjab, Constitution Bench, 1963 Supreme Court, page 1909. The Supreme Court for the first time said, because the argument was the Honorable High Court doesn't have the power of review, unlike the Supreme Court, because in Constitution, specifically Supreme Court is given the power of review, but Constitution is silent so far as the High Court's power of review is concerned. The Supreme Court said in Shivdan Singh's case, High Court is a constitutional court, it has plenary jurisdiction. The power of review is inherent, including, so inherent powers are there. Court has got inherent powers, CPC 151, CRPC 482, now a new provision is there, corresponding provision. So court and tribunal also has got inherent powers by the judgment of the Supreme Court by virtue of judicial pronouncements. But the statutory body, my lord, doesn't have the inherent powers unless and until is specifically vested. Over here, my lord, Regulation 26 does give some kind of inherent powers, but those powers are limited to sub-regulation 2 of Regulation 26.
They are in conflict or militate against one.
Yes.
That is your basic submission.
So far as the present case is concerned, apparent conflict is there. So it has to be construed harmoniously. So Greater Noida Authority doesn't come on my way. So, my lord, here is a case that there is no alternative remedy is available. And as such, the present case is not only a case of inherent lack of jurisdiction, but it is also a case of acting beyond the jurisdiction, which I will deal with, the second leg of my argument, acting beyond the jurisdiction or exceeding the jurisdiction when I deal with quote-unquote fulcrum of the case. That's a beautiful term used. The core issue, section 93, the scope of.
Yes.
As to how the power were exceeded. And my lord, most importantly, assuming for a moment, not admitting that there is some kind of an alternative remedy, that remedy is also not effective. It is not adequate. The reason is, my lord, presently in APTEL, there are 4 members including the chairperson. Out of the 4, who are the 2? The 2 are those members who are the author of Jindal case. They have taken a view already that there is a power of recall. In fact, my lord, these 2 members, one Sandesh Kumar and one Mr. Bhatti, I think Jindal case, kindly, just to show your lordship. Jindal is here. Is here. I'm having it. Who are these two out of the four? Yes. Yes.
Where do you say that from?
It's in the judgment.
Jindal. Lordship will have a.
It's in the compilation.
No, I have the judgment.
Virender Bhatt. Virender Bhatt, member judicial, along with
Where is
them,
it mentioned?
is mentioned. Yeah. And at the top. And Sandesh Kumar Sharma, member technical. At the very top.
I'm looking at the Supreme Court judgment. Where's the judgment of the APTEL?
Which compilation is?
2024 SEC online.
SEC 6767.
Milord, it is 2024 SEC online, APTEL. It is the order of the APTEL.
Oh, okay, okay.
17. It's in the compilation.
It's in the compilation.
It's compilation show kindly. Just a minute.
Compilation.
The compilation is commission. Just a minute. In commission's compilation, serial number 4.
Where's commission's compilation?
Page 24.
One second. It is not, yeah, article. Page
24.
Page
24.
That is Jindal India.
Yes.
Not global.
Not global, Jindal. Sandesh Kumar Sharma, member technical, and Virender Bhatt.
Where?
And Milord, in fact, this very particular bench has passed 2 orders on the line of Jindal. Jindal is one, and there is another. Both they have taken a view.
No, I'm not fast to say anything, Mr. Tiwari. That is, that'll come at that stage. Suppose that we have not ruled on anything.
I'm talking about effective remedy.
Effective. That is subject to that I think we avoid that part. We just stick to the core law points.
But just by the way, I brought this to you, my lord's notice. Though I'm dealing with the core.
And you said we'll stick to the core issues of what they've raised.
Now, my lord, comes the next. Writ of certiorari and the rule of exhaustion of alternative remedy. It was argued that, in fact, my lord, to argue that alternative remedy, first of all, I have said there is no alternative remedy.
Okay.
Assuming without admitting there is alternative remedy, it is not effective. I'm keeping it aside for a while. The second leg of my argument is that this alternative remedy need not be exhausted. There is no rigidity about this rule of exhaustion of alternative remedy. Because in any case, when we pray for a writ of certiorari lies not only when there is inherent lack of jurisdiction, but there is also an exercise of power in excess of jurisdiction. Whether we exceed jurisdiction or whether there is inherent lack of jurisdiction, in either of the situation, a writ of certiorari lies. My lord, to argue to the contrary, in order to argue to the contrary, the general principles of the writ, my lord, were referred to in various Supreme Court judgments, which is absolutely out of context, which have no relevance whatsoever. On a writ of certiorari, my lord, I place 2 constitution benches.
Okay.
Hari Vishnu Kamath, 7-judge constitution bench. Let us deal with the writ of certiorari specifically, instead of talking about the general principles of writ jurisdiction. The Hari Vishnu Kamath, but before I come to Hari Vishnu Kamath, my lord, I will refer to their own judgment. To their own judgment, I mean to say the judgment they cited. My lord, South Indian Bank Limited versus Naveen Matthew Philip, 2023 SEC online, Supreme Court 435 was referred to by the Learned Council of Public Utilities. It is there in the compilation, my lord, of the Public Utilities. My lord will find the volume 1 of the compilation. Volume 1 of the compilation, serial number 6. South Indian Bank Limited versus Naveen Matthew Philip.
Yes.
On the doctrine of exhaustion of alternative remedy. The scope of the writ. Now, my lord, interestingly, my lord, while referring to South Indian Bank Limited versus Naveen Matthew Philip, very conveniently, paragraph 16 was read. Paragraph 16 onwards. Skipping, my lord, paragraph 14. Let us read paragraph 14 now, which was not read. Since it was not read, I have to read it. Page 34.
Yes.
Paragraph 14. Para 14 deals specifically with the writ of certiorari. A writ of certiorari, I'm sorry, page 37, my lord, of the compilation, volume 1. A writ of certiorari is to be issued over a decision when the court finds that the process does not conform to the law or statute. In other words, courts are not expected to substitute themselves with the decision-making authority while finding fault with the process along with the reasons assigned. Such a writ is not expected to be issued to remedy all violations. When a tribunal is constituted, it is expected to go into the issues of fact and law, including a statutory violation. A question as to whether such a violation would be over a mandatory prescription as against a discretionary one is primarily within the domain of the tribunal. So also the issue governing waiver, acquiescence and estoppel. We wish to place reliance on the decision of this court in Hari Vishnu Kamath, Sayyid Ahmad Ishaq. Now, my lord, this is 7 Judge Constitution Bench. They have referred to Hari Vishnu Kamath. I will not separately refer to it. I read the relevant quote. Then the question is whether there are proper grounds for the issue of certiorari in the present case. There was considerable argument before us as to the character and scope of the writ of certiorari and the conditions under which it could be issued. The question has been considered by this court in Parry & Co. versus Commercial Employees Association Madras and Virappa Pirle Raman and Raman Limited. 52, 1 SEC 334, and Abraham Abu, all these cases referred to, followed by TC Basappa versus T Nagappa. On these authorities, the following propositions may be taken as established. 1. Certiorari will be issued for correcting errors of jurisdiction. Errors of jurisdiction, as when an inferior court or tribunal acts without jurisdiction or in excess of it. This is important. Either it acts without jurisdiction or in excess of it, or fails to exercise it. So, my lord, like three concentric circle, the writ of certiorari has three facets. Number 1, failing to exercise a jurisdiction vested in you. Number 1. Number 2, jurisdiction is vested in you, but while exercising the jurisdiction invested in you, you exceed the limits of the jurisdiction. And thirdly, you have no jurisdiction at all, still you exercise the power. In either of the three situations, writ of certiorari lies. This is the, my lord, fundamental principle, my lord, which has been ruling this land since the very beginning, my lord, since independence. Or even prior to that, the Privy Council and the House of Lords.
Then under 227 also you could have come.
Oh yes, either way.
Supervisory jurisdiction, if we say.
Even 226, 227, either way, my lord. Certiorari it is, because ultimately, my lord, what I am challenging, I am on the issue of jurisdiction. The entire court is there, my lord, I need not. The same principle, my lord, was reiterated by another 5-judge constitution bench. This is 7-judge constitution bench, Hari Vishnu Kamath, reiterated in South Indian Bank Limited. And the same principle was reiterated, my lord, in State of UP versus Muhammad Noor, 5-judge constitution bench, on the scope of the writ of certiorari. The citation, my lord, is State of UP versus Muhammad Noor, AIR 1958, Supreme Court, page 86. Page 86, relevant para 10 and para 11. And Lordship have also para 10, para 11. A book is there. Kindly, I'll just read. 1950. Same principle below 10 and 11. I need not again, because reading the whole thing, same Hari Vishnu Kamath, 7-judge constitution bench, South India, same principle they are reiterating.
Okay, wrong judgment.
1958.
Yes. 86.
Page 86. Okay.
Lordship may take the printed copy.
No. This.
In my write-up, I will quote it itself in italics.
What note? Yes. Arbitrary judgment.
So, my lord, I will not travel further. I relied on their own judgment, which they refer to South Indian Bank Limited, paragraph 14. Then Hari Vishnu Kamath, 7 Judge Constitution Bench, the para 21 of the Hari Vishnu Kamath, and also
Muhammad says has to be loud and obstructive as to cause, like it's to, to.
principle remains the same, my lord. The 3 concentric circles.
Okay, yes. Next point.
Para 10. So then, my lord, yet another argument was on maintainability.
Yes.
In paragraph 6 of their counter affidavit, and it was argued also by my learned friend appearing for the public utilities. In para 6 of their counter affidavit, referring to letter dated 4th February 2024, it was alleged that the petitioner in its letter dated 20th December 2024, in its letter is 24th December 2024. Counter affidavit is dated 4th February 2025. Their counter affidavit of public utilities. In para 6 of their counter affidavit, they say that in our letter dated 20th December 2024, we agreed to make the payment in terms of tariff order. So since we agreed in our letter to make payment in terms of the tariff order.
Sorry, 1 second. Yes.
Since we agreed to make payment in terms of tariff order, now we can't turn around and challenge it because we had agreed in our letter of 20th December 2024. Now, my lord, in their counter affidavit, they have not annexed our letter of 20th December 2024. I have given details of that in my reply in paragraph 5 of the counter affidavit. Lordship may see our reply.
You rejoined the email.
20th December 24. No, in our reply, yes.
No, this is not a reply.
It's not annexed here in your reply.
It's not annexed, my lord, in the reply. But, my lord, they orally stated, they made a statement, we have rebutted the statement, my lord, we have given the explanation. The letter, the paragraph 5, my lord, will find.
That the government's made para 6 so and so.
Yes, that the government's made in para 7 of the affidavit. Para 6. Yes. Averments made in para 6 of the affidavit in opposition and a reply are vehemently denied. It is categorically stated that the respondents are trying to such and such by letter dated 2012-2024, protest letter of petitioner 1, such and such protest letter of petitioner 2. Petitioner 2 we are not dealing with right now, petitioner 1. 24th December 24. 20th December 24. It is stated that the petitioner raised clear objection to the payment of tariff as per the tariff order dated 24/10/24. The petitioner 1 in its letter dated 2012-24 in no ambiguous term stated part of the writ petition. Paragraph?
Annexure 12.
Annexure 12 series. Lordship may straight away turn to the letter itself. Sorry. In the writ petition we annex the letter. 12 series. Page 145, my lord, of the writ petition.
Our writ petition.
WPC 9. Sorry. There are lots of. Page 145. Please refer to electricity bill cited such and such, wherein you have raised the electricity bill for the period 1st November 24 to 1st December 24 with the energy charges such and fixed charges as such and such, which is sub judice before the Honorable High Court of Meghalaya. In this regard, we wish to inform you that we are making the payment of electricity bill calculated as per the last bill paid for the month of October 24 since April 24, amounting to such and such, wide reference number such and such. However, as an esteemed consumer of MEPDCL be paid remaining difference of the electricity bill amounting to such and such, less such and such under protest without prejudice to all our rights, remedies and contentions under the law through NEFT wide reference number such and such. This is, my lord, no waiver and no acquiescence. It's clearly under protest. So all the letters were like this only. So no question of waiver and no question of acquiescence.
Okay.
So therefore, my lord, this contention is misconceived. Then, my lord, suppression of material fact.
Yes. That's the last point. Maintainability.
Yes.
Yes.
There is one more. It was also argued that 2 writ petitions were filed for the same cause of action. Of course, the nomenclature constructive res judicata was not used. But basically, my lord, that can be the only is that the petitioner suppressed the material fact by not disclosing these 2 letters. No, my lord, let us have a look at the 2 letters. And then let us ascertain if page 31, my lord,
yes,
of their counter affidavit. Page 31. We have received the electricity bill for payment today only, whereas the date of payment shown is 24 January 25. Sir, this is in violation of MSERC Supply Code 2018, according to which 15 days of time is to be given and not 6 days. You are requested to kindly revise the date of payment as 31st January 25 and serve us the revised copy of the bill at the earliest without any further delay. The letter only indicates we are buying time. As to whether buying time is for the purpose of payment of bill or for the purpose of coming before the Honorable Court is for us. Now the question is, my lord, whether this can amount to suppression of material fact. Now what is material fact? The material fact, my lord, is that particular fact, non-disclosure of which would have gone to the very root of the matter. The Supreme Court says so in many cases. Every single fact cannot be stated to be material fact. The material fact has to be such that had my lord not been aware of this very particular fact, the decision of this Honorable Court could have been different on the very merit of the case. I place one judgment on this very issue on the material fact. Lordship may refer to, my lord, 2004, 7 SCC, page 166.
7 SCC.
Yes, 2004, 7 SCC, page 166. 166. Relevant para is paragraph 1.3. You may have. Paragraph 13, 1.3 at page 173.
Yes. What do you want to show from here?
My lord, I
as
just
general
show.
rule.
Yes, what is a material fact? As a general rule, suppression of a material fact by a litigant disqualifies such litigant from obtaining any relief. This rule has been evolved out of the need of the courts to deter a litigant from abusing the process of court by deceiving it. But the suppressed fact must be a material one in the sense that had it not been suppressed, it would had an effect on the merits of the case. It must be a matter which was material for the consideration of the court, whatever the view court may have taken. This is what the material fact is.
It is not such a crucial, doesn't have such crucial.
Nothing,
value as
letter
to
is
affect-
neither relevant.
Okay.
My submission is
I understand
letter.
that if
Yes.
material fact will be like change the direction of the entire discourse.
That's
like
it.
if material fact is
Yes.
is
So letter
suppressed.
below my submission is neither relevant
Yes.
nor material for adjudication of the issues raised before the Honorable Court. The letters have no material bearing on the merits of the case. That is a material. So it is not material. Now, my lord,
You come to collective right, individual right.
I'll come to that also.
Yes.
Now, filing, I'll deal with this now. This was argued in the, because the argument was 2 writ petitions were filed. So 2 writ petitions, first of all, my lord, I do not know in what manner the 2 writ petitions, my lord, are not maintainable before the Honorable Court. But
No,
what
they have
is
said that what they have argued is that it's overlapped. Now your
Overlapping,
it's already on record under the your
Yes, it
umbrella
is
group
there.
with
It is
regard
there.
to the challenge. Okay.
It is there on
Then the
record.
thing is that you have gone one step further and added another prayer. That's the only thing. Now, whether that both can be considered together.
I'll put it this way.
Yes. Can you just give
An
me 5 minutes?
umbrella.
Just give me 5 minutes, yes.
Very
Yes. Because we want the next point before we start that.
So now, my lord, on overlapping of the writ petition.
Yes.
So, since, my lord, I am the counsel, my lord, of
Who is
an
the counsel
individual
appearing in
petitioner.
this BIA? Who is the lead counsel in the other matter?
Mr. Paul, I understand.
He is appearing only in that matter.
Order matters, my lord. And BIA, my lord. This is the main matter, my lord. Item number 43, my lord.
Yeah, by BS mean he is appearing in that matter, plus other matters also.
My lord, the order matters 12 to 19, my lord.
Okay, right. Mr. Tiwari is not there in that BIA matter. Okay.
I am not. Now, my lord, appearing for an individual petitioner, I asked myself as to when the cause of action became complete in my case.
Yes.
The cause of action became complete, my lord, when after the order of 23rd of August 2024, by which the previous tariff order was recalled,
Yeah.
then there was a state of vacuum. I was paying bills, as per the old tariff. I continued to pay. Any person, my lord, would not like to litigate immediately because I was hoping against hope. Even if there is re-examination, maybe if there is a belief that two persons ought to have signed it and only one signed it, maybe on re-examination now, same tariff order which was recalled will be reissued again with two signatures. That's a reasonable view. Anybody can take such a view. But when that did not happen, and instead, altogether a new tariff order came into being on 24th of October. 24th of October 2024, the cause of action became complete. Then I came before this honorable court, number one, challenging 23rd August 2024 order of recall, because that is the mother. And 24th October 2024 new tariff order is a creature of the consequence which came into existence on 23rd of August. I had to challenge both. My lord, I was enforcing my individual fundamental and the legal right before the honorable court. I am not concerned with the umbrella organization. One person doesn't control the umbrella organization. Umbrella organization came at a particular stage in its own wisdom. I can't dictate to anybody as to whether umbrella, learned counsel of the commission, my lord, that was a move which he made in his, my lord, he is entitled to do that. But lordship would look at it from a different way. Learned counsel appearing for the commission was right in saying as to which individual right or which fundamental or legal right of the association is violated. A question can be raised, but such a question can't be raised so far as I am concerned. Merely because one umbrella organization on the name of, my lord, number of industries came before this honorable court assailing the legality of 23rd of August 2024 order of recall, that, my lord, cannot extinguish my fundamental and legal right of enforcing, my lord. It cannot extinguish, my lord, my fundamental and legal right to approach the honorable court on completion of a complete cause of action and to seek appropriate remedy.
Right.
This is, my lord, my answer.
Any authority on this individual right and collective
I'll
right?
come to that, my
With
lord.
that
My
overlapping
lord,
factor.
on overlapping, interestingly, my lord,
Yes.
what judgment they had cited? The judgment cited is Sarguja, Dario, Nawab Hussain. My lord, those judgments are authority on what? Those judgments are of the authority on constructive res judicata and res judicata, the principle. Now, my lord, what is constructive res judicata? What is the ratio, my lord, of Sarguja, I ask myself, and Nawab Hussain? Those are the cases where one Mr. X, an individual, files a suit. Suit gets dismissed. That is Nawab Hussain. Suit gets dismissed. Thereafter, for same cause of action, he files a writ petition. Matter goes up to the level of the Supreme Court. That is Sarguja. That is Nawab Hussain. Sarguja is the same principle.
Yes. Same principle.
Sarguja is same principle. That is correct.
Yes.
Or, my lord, another issue. I file a writ petition. And I withdraw the writ petition without liberty. And then I file a second writ petition on same cause of action, since there was no liberty taken while withdrawing a writ petition number 1. That is constructive res judicata. That has been explained in Sarguja. That is Sarguja.
Yes.
And Nawab Hussain, my lord, practically the principle is the same. That is why, my lord, we were always trained by our seniors to take liberty before withdrawing the petition. Those principles don't apply here. This is the first writ petition I filed. My individual right can't be extinguished by an umbrella organization.
On the same cause of action.
Yes. There is no same cause of action so far as I am concerned. My writ petition is only one.
Okay, yes.
So therefore, my lord, Sarguja and Nawab Hussain, I need not really refer to the paragraphs on constructive res judicata and res judicata. Those principles are not applicable in the present case.
Yes.
Now, my lord, I come to maintainability part is now, my lord, over.
Over, yes.
Now, my lord, the second component of their argument, the judgments and order of this Honorable High Court.
Yes.
I have to deal with them very carefully. Let us look into the circumstances, situations wherein those orders were passed and the nature of the orders. My submission is going to be after referring to the judgment and the orders of this Honorable Court on the subject. Nothing has been decided.
Okay.
No law has been laid down. And this is an area which is absolutely grey, which Lordship will consider. I'll come to that, my lord. All this is in the compilation. It was there, my lord, in their counter affidavit. Counter affidavit of respondent 3 to respondent 5. There are 3 annexures, my lord, annexure R3, R4 and R5. I will refer to all these 3 annexures.
Yes.
Let us turn to annexure R3 first. Page 33.
Yes.
This is my lord's order.
Yes.
Short order, I will just read this. I have to read this, my lord, to make things clear. Page 34 of the counter affidavit. This application has been filed by the petitioner company assailing the action of the respondent corporation in not allowing temporary disconnection of electricity to their plant, for carrying out major repairs, upgradation and maintenance, and further for charging fixed charges while the impugned electricity bill dated 20th May 2024. So consumer came before the Honorable Court. The grievance of the consumer being, look, I am not being allowed to get my electricity disconnected, and still, even if I cut my electricity, I will have to pay the fixed charges. This is how, my lord, these public utilities are harassing the consumers, because he had to carry out the major repairs. He came before my lord. On such a writ petition of the consumer, my lord, these are the certain facts. The brief facts are that the petitioner company to upgrade and undertake major maintenance work had to shut down its plant for at least 3 months, and in this regard, such and such, all details, my lord, here given, not very necessary. This is the core. Paragraph 3.
Yeah.
Such and such senior counsel assisted by such and such for the petitioner submits, so he was the counsel of the consumer, that the action of the respondent corporation in demanding the settlement of dues which are still under adjudication before allowing disconnection is arbitrary, and has stressed that this court in the consent order dated 15th February 24 had held that the tariff collected by respondent 2 and the special tariff paid by the petitioner company would be subject to the final adjudication by the MSERC. He therefore submits that interference is called for by this court in exercise of discretionary powers under Article 226 of the Constitution to set aside the impugned bill dated 20th May 24. Before adverting to the submissions of the respondent corporation, it is to be noted herein that in the course of these proceedings, the petitioner company, without waiting for the disconnection to be carried out by the respondent corporation, had on its own accord disconnected the electricity connection on 21st March 24 and has stated this fact at para 8 of the writ petition. It has also been submitted that the plant now has resumed operations and there is no longer any necessity for disconnection. And so, in effect, the only aspect for determination that remains would be whether during the period of disconnection for which no electricity had been consumed, the petitioner company would be liable to pay fixed charges. In this respect, this court, to effect closure of the matter, had directed the learned counsel for the respondent corporation to obtain instructions whether payment of 50% of the fixed charges for the period of non-consumption of electricity by the petitioner company would suffice to end the matter, so as not to cloud the instant issue with the larger issue pending before the MSERC. However, the same was not agreeable to the respondent corporation, and as such, the said proposal stands closed, and the matter is taken forward before this court for disposal. Coming to the submission of learned counsel such and such on behalf of the respondent corporation, it has firstly been contended that the petitioner has alternative remedy available by approaching the Consumer Grievances Redressal Forum. Alternative remedy before Consumer Grievances Redressal Forum constituted under the MSERC. It has further been submitted that the petitioner has no right to seek waiver of fixed charges as Section 45 subsection 3 of the Electricity Act 2003 provides for levy of fixed charges, and that Regulation 6.6 of the MSERC Supply Code conditions for temporary disconnection would not be available to the petitioner, as admittedly the disconnection had been done by the petitioner company itself. It has also been argued by the learned counsel that the issue of stay on the recovery of previous dues is not the relief claimed in the present case, and further that even otherwise, as the MSERC is deciding a special tariff matter, any order from this court might interfere and prejudice the adjudication before the commission. As noted earlier, as the main bone of contention no longer exists for consideration, that is the temporary disconnection as requested by the petitioner, which was sought to be enforced by seeking directions from this court, and further the proposal for closure not being agreed to, this court accordingly, due to the existence of alternate remedy as provided under the Regulation 4 Sub-Regulation 2 of the Regulation 2007, desist from entertaining the instant writ petition any further, leaving it to the petitioner to seek appropriate remedy before the said forum. The instant writ petition on these circumstances stand closed and disposed of. Nothing more. The present issue for the consideration of my court is entirely altogether different. Nobody can have quarrel with the alternative remedy, my lord, which is available in the circumstances under which this writ petition was filed. Issue is entirely different. The second order, lordship may see now. It begins at page 40.
Yes.
These petitions, page 40, the second. These petitions have been filed against the orders passed by the learned chairperson of the Meghalaya State Electricity Regulatory Commission on the ground that the orders are without jurisdiction and suffer from procedural infirmities, as the issues concern the grievances of individual consumer and are not disputes between licensee and generating companies, in which case the commission would have had jurisdiction to adjudicate. So, my lord, the argument was that here the individual consumer has come and the grievance is not, the dispute is not between the commission, and there is no dispute between the licensee and generating companies, in which the commission would have had jurisdiction to adjudicate. So, commission has no jurisdiction. Such and such on behalf of petitioner submits that apart from the lack of jurisdiction, the impugned orders, even if the regulatory commission was competent to take up the matter, were non-est in law, as they were passed without the prescribed quorum. Attention of the court with regard to jurisdiction and quorum has been drawn to the judgments of Honorable Supreme Court. Those judgments may not have not been mentioned here. The provisions of Regulation 2007 and the Electricity Act 2003. General, my lord, observation has been made on these provisions. At the outset, such and such senior counsel for respondent fairly concedes that Meghalaya State Electricity Regulatory Commission had no jurisdiction to entertain the matter and pass orders thereon, as has been occasioned in the instant case. So, my lord, both the sides agreed. Yes, on the submission of the learned counsel for the parties, these writ petitions are disposed of without contest. So, there was no contest either. With the following observations. In Maharashtra Electricity Regulatory Commission versus Reliance Energy Limited reported in such and such, it has been held that where the state concerned had created a proper forum for redressal of grievances of consumers, the State Electricity Regulatory Commission had no jurisdiction to adjudicate upon such matter, and even under 86(1)(f) of the Electricity Act 2003, the said commission had no power to adjudicate upon disputes relating to grievance or consumers, and it could only adjudicate upon the dispute between the licensee and the generating companies. So issues are, even if the issues pertain to tariff and other things, one can go before the APTEL. Here, my lord, issues are entirely different. 86(1)(f) of the Electricity Act for convenience is quoted here in below. It is quoted. Licensee and generating companies. 86(1)(f). With regard to quorum, the Honorable Supreme Court in the case of Tamil Nadu Generation and Distribution Corporation Limited versus such and such has held that the presence of one judicial member is a must in decision presence of one judicial member is a must. In a decision taken by regulatory commission, which are relevant are quoted here in below. The entire quote is there. Now, my lord, this should not disturb us even for a second, for the very simple reason, here the order was signed by, my lord, a judicial member, Mr. R.K. Soni, retired district and session judge. The Meghalaya State Electricity Regulatory Commission Conduct of Business Regulation 2007 with regard to quorum has at section 10 provided as follows. Quorum, my lord, the provision has been quoted, where the commission has also one member or more. The quorum of any meeting shall be 2, including the chairperson. In the fact and circumstances of the case, these petitions are allowed and accordingly disposed of. The respondent are such and such. My lord, my submission is number 1, the facts of this case are entirely different. Number 2, the case, there was no contest in the case. Number 3, Lordship has not laid down any law as such. Lordship has not laid down any law affecting, my lord, the core issues involved in the present list before your lordship.
What about the division bench judgment?
Next. Yes, I'll come to that. The writ petition is directed against an order dated such and such passed by the Meghalaya State Electricity Regulatory Commission at an interim stage of the proceedings instituted before it by the private respondent there at the interim stage. The writ petition was filed. There is no dispute that the order impugned is amenable to an appeal under section 111 of the Electricity Act 2003. Now let us see the nature of the order. However, the petitioner power company submits that the alternative remedy is neither efficacious nor appropriate. It was the power company, my lord, which had approached. Alternative remedy is neither efficacious nor appropriate in the present case, particularly since the primary prayer in the petition before the State Electricity Regulatory Commission is contrary to a finding rendered in an order dated September 5, 2022 passed by this court. Ordinarily, when an efficacious alternative remedy is available, the writ court exercises a degree of self-restraint before entertaining a petition under Article 226 of the Constitution filed without availing of the regular statutory remedy. The exceptional situations in which the alternative remedy is disregarded and the writ petition is received may be when the order impugned is found to be in breach of the principles of natural justice or wholly without jurisdiction or absurd to the meanest mind. In the present case, the writ petitioners claim that since the private respondents herein had earlier approached this court, the objection now raised that the writ court should not entertain the present petition would not lie in their mouth. However, such contention is unacceptable. It is possible that in view of the order dated September 5, 2022 passed by this court, there may not be any merit in the petition filed by the private respondents before the commission. However, such an argument may be carried in appeal, and merely because the petition has been entertained or an interim order has been passed does not amount to commission having acted without jurisdiction of the kind that would excite the writ court to receive the petition without the alternative remedy being exhausted. The merits of the matter have not been gone into. The petitioner power company is permitted to avail of the alternative remedy by urging whatever ground that may be available to it in accordance with law. Such and such are disposed of. Again, my lord, no law has been laid down. We don't know the subject matter. We don't know the issues involved. We don't know the argument that were made. My lord, at least, my lord, since I am not privy to the details, my lord, I am absolutely at a loss. My lord, I only ask myself, and I wonder, my lord, the issues, my lord, that have been raised before my lord in the present list, whether those issues were raised here. Apparently, my lord, the plain reading of the order of the division bench suggests those issues were not there before the division bench. Very substantive issues have been raised before my lord in the present case. This is an area, my lord, not to speak of this very honorable court. Even Supreme Court has not decided this issue. Except, and the learned counsel of the commission was right in saying, except the orders of the APTEL, we have nothing. We have, of course, there are judgments of the Supreme Court which I will show, dealing with pari materia provision. Circumstances again there are a bit different. I will come to all that in my third leg of my argument. Practically, my lord, this is the grey area. So, my lord, there is nothing in any proceeding before the honorable court which will, my lord, tie our hands in any manner, or that will tie the hands of your lordship in deciding the present case. Now, my lord, I come to the third and the final argument, the fulcrum, and that's indeed a fulcrum. The scope of section 93.
Yes.
If I remember correctly, my lord, it has been argued by the learned counsel appearing for the public utilities as well as learned counsel appearing for the commission that section 93, which is a saving clause, it's a saving clause, my lord, there is no doubt about it. It saves. Now what it saves? It was argued, possibly, my lord, I beg your pardon, my lord?
Sorry, carry on.
It's a saving clause, and now the question is what it saves. The argument was, and possibly for this, you know, they relied on the orders of the APTEL, which are in their favor. The interpretation of the APTEL in the Jindal case and other case, similar case. The interpretation of the APTEL was that section 93 saves those very proceedings which were initiated before a commission which was improperly constituted. I think this was the argument. A commission which was improperly constituted, and if the proceeding before improperly constituted commission ends in finality, those proceedings shall not be invalidated merely on the ground that the commission was improperly constituted. In any case, I said that's a de facto doctrine, like very well established. Even if you don't make a provision in the law, the doctrine will prevail. Very well, section 93 as a saving clause made it very clear. But the question is, can we confine the scope of section 93 only to that part? Or whether section 93 would also encapsulate within itself a situation where action was initiated before a properly constituted commission. Lordship will just see the test, the touchstone. First case, improperly constituted commission from the very beginning. Ended in finality. You say, no, it's all right. Saving clause, de facto doctrine, etc. Second situation, properly constituted commission. Proceeding properly began.
Improper.
Just before the finality, one person retires. Does it mean the entire proceeding will be invalidated? My lord, the second situation is on a far better footing than the first situation. Okay. That's going to be my submission. Far better footing. And I will demonstrate the approach of the Supreme Court also. And thereafter I will make a submission that 121 order, under section 121, the order which APTEL had issued, even if it is administrative order, that should be more appealing to my lord. It's a different question whether it was binding or not binding. I am going to demonstrate with the help of the Supreme Court judgment that very administrative order was binding on the commission. But so far as my lord is concerned, my lord's hands are not tied. Before my lord, there are two schools of thought. There are two schools of interpretation of the scope of section 93. One is the Jindal school, the APTEL, two orders. Other one is 121 order. Which one is more sound and logical? Lordship will weigh the two. And Lordship will interpret that, and Lordship will examine the issue.
Okay.
So now, my lord, the first one. Now, my lord, there are judgments. The judgment which was cited by the London Council appearing for the commission was the Bombay case, Kamber Jivaji versus State of Maharashtra. That is 2010, SCC online, 2010 SCC online, Bombay, 838.
It's not in the compilation.
My lord, it is not in the compilation. It was given separately by the London Council appearing for the commission. But I have, my lord, the second copy. I will give it to your lordship. If my lord is not, I'll give. Is there? Very well. Now, my lord, before.
It's regarding that analogy with the Waqf board.
Yes, my lord, that's very interesting. It's Waqf case.
Yes.
Now, my lord, it was very. I'll just give, my lord. I'll explain this. Then I will come to the relevant paragraph. What happened in this case, my lord? Kamber Jivaji, the Waqf case, the division bench judgment of the Bombay High Court. Here, my lord, the proceeding did not even begin before the commission. For Waqf board, my lord knows very well. This is, my lord, a board which deals with the Muslims, their properties, land, etc. We all know these days, my lord, yes. We keep on hearing Waqf and all that. Now, my lord, Muslims comes in various colors. The various sects are there. there are Sunnis, there are Shias, and there are others. Over here, my lord, in this very particular case, the board which was there under the Waqf Act, in this very board, the numbers of elected members were less than the numbers of nominated members. Elected members were less, nominated members were more, and there were vacancies of the elected members. That's number one. Number two, there was no representation from the Shias also. There was no representation from Shia. It was in that situation proceeding was not being initiated by the board. So, my lord, the Honorable Court was approached seeking mandamus to the board to start the proceedings. The argument was there is a saving clause. What's the difficulty? Why are you not proceeding just because there are vacancies? So what if you would be improperly constituted or composition would not be there? And interestingly, my lord, the state supported this very kind of a contention. State said, yes, there is a saving clause. So proceeding can be initiated. The court said, yes, saving clause is there. But just because there is a saving clause, does it mean with your eyes wide open, you will intentionally begin the proceeding? And you will continue with this? Is it a license to do illegal things? Is this the way? And then, my lord, importantly, the court also said, look here, look at the very spirit. Muslims should be properly represented in the board. Shias are not represented. Democratic element is over here is missing, so this will be improper. And my lord, court made it very clear. Court said that the judgments that were cited before us, those judgments are in respect of concluded proceedings and the effect of the saving clause of not invalidating the concluded proceeding. Here is the case, proceeding is yet to begin or the pending one. There is a distinction. And this is what, my lord, the ratio of the whole case is all about.
Okay. Yes.
As my lord, we always say, a judgment is not an authority. Judgment is an authority for what it actually decides and not from what can be logically inferred from it. This is, my lord, the entire ratio. Lordship will see paragraph 20 of the Waqf case.
Yes.
In para 20, my lord, the Supreme Court judgments were also referred. I will come to those Supreme Court judgments thereafter.
Para 20?
Yes, para 20. The state government, however, permits.
Yes.
State government, however, permits Waqf board to proceed further with consideration of petitioners' matters, and respondent number 2 board, as also its members, respondent number 3 to 6 also intend to decide the same. They rely upon section 22 of Waqf Act to urge that no defect in constitution or existence of vacancy in Waqf board can invalidate its proceedings. Their section 22, my lord, is pari materia to our section 93 here. She such and such has, during arguments, submitted papers containing similar provisions from other enactments with the stand that this arrangement in statute is a standard practice. However, question before us is not about invalidation of proceedings already concluded, but pertains to pending one. This is important. Section 22 reads as under pari materia, my lord, 293. It is obvious that said section is not an enabling provision, but a saving one. It cannot and does not mean that Waqf board with a defective composition and vacancies is allowed to proceed to decide, and Parliament has given it a license to do so. After 4/9/2008 notification, there were 9 members on Waqf board, and at present its strength is only 4. Precedents cited by learned senior counsel in this regard does not show any such leave to decide despite knowledge of defect. Leave to decide despite knowledge of defect. Honorable Apex Court in Guljari Lal Agarwal versus Accounts Officer, I will deal with this case, my lord. Guljari Lal Agarwal versus Accounts Officer found that National Commission functioning under Consumer Protection Act 1986 set aside concurrent orders of District Forum and State Commission on the ground of jurisdiction, as President of Commission was not party to decision and it was passed by only 2 members. In para 11, section 29 capital A of that act, worded like section 22 of Waqf Act, is noticed, and then in para 17, Honorable Apex Court has gathered intention of legislature not to render state commission non-functional in absence of president, and it is found that in his absence, senior-most member is to function as president. Facts in Akhil Bharat Goseva Sangha versus State of Andhra Pradesh reveal that the chairman and member secretary of AP Pollution Control Board did not possess necessary qualifications, and Honorable Apex Court noticed that High Court did not address a specific breach of statutory requirements in this respect, though it noticed that some of its members were scientific experts. In this background, the Honorable Apex Court considers Section 11 of the Water Prevention and Control of Pollution Act 1974, which provides in terms that no act or proceeding of a board or any committee thereof shall be called in question on the ground merely of the existence of any vacancy in or any defect in the constitution of the board or such committee as the case may be. Therefore, applying Section 11 of the Act, which clearly provides that no act or proceeding of APPCB or any committee thereof shall be called in question, Honorable Apex Court concluded that even if there was some defect in the composition of APPCB, that would not invalidate the consent order issued by it. Observations of under single judge of Honorable Delhi High Court in Trilochan Singh Rana versus Joginder Singh Bajwa are cited to explain interpretation of Section 22 of Delhi Sikh Gurudwara Act 1971. That section is in same words as Section 22 of the Waqf Act. The act of managing committee in co-opting a person to fill a vacancy of co-opted member without first filling in vacancy of elected member is found to be saved by Section 22 of said Delhi Act. All these judgments consider challenge to completed actions or decisions, and agreed parties there did not try to stop the process midway, as is attempted by petitioners before us. It is clear in present facts that Section 22 cannot be invoked by state government to urge that it cannot be asked to fill in vacancy of Shia member. Because the state did not want to fill the vacancy of the Shia member. So court said that such a plea can't be made. Such provision also does not help it to argue that respondent to board can decide without its existing composition when number of elected members is less than nominated one, and such decision will be valid. Section 22 of the Waqf Act carries with it an important rider that invalidation is not possible by reason only of, quote unquote, existence of vacancy or defect in constitution. Hence, if invalidation is sought only on one ground, the protection under Section 22 will be available to completed actions. But when more number of elected members is mandated by Parliament with idea of infusing more democratic element or Shia member on Waqf board is prescribed to give the people of that sect an effective voice in Waqf board affairs, the omission to have such more elected members or a Shia member may prejudice the decision of Waqf board. It cannot be ignored that Waqf board has to decide by majority, and presently more than 50% of its posts are vacant. The object of Parliament behind providing such type of arrangement and representation stands defeated. It is equally important to note that the state government is not coming up with any explanation or reason for not filling in these vacancies or for permitting the Waqf board as it is. If interpretation of respondents is accepted, there cannot be any challenge at any time to composition of Waqf board, and the state would be free to violate a scheme of Section 14 of Waqf Act. Section 22 is not intended as license to it to perpetuate such defects in composition or continue with such vacancies and thereby render other provisions of Waqf Act nugatory and irrelevant. We are not in position to accept the arguments of such and such senior counsel, at least in presented petition, that purpose of Section 22 is dual, to validate the acts and proceedings of board and to keep the Waqf board functional despite defects in composition or vacancies in it. So, my lord, finally, it is always the context. We have to see the spirit of the act, what it envisages, what is the purpose. Idea is, yes, there is a saving clause.
So contextual, not textual.
Always contextual, my lord. And my lord, in the other cases, Guljari Lal Agarwal, Trilochan Singh Rana, in their cases, my lord, yes, there was a defective composition. Defect in composition, proceeding got completed, acquired finality, and then the court said, yes, even if the composition there was defective, the saving clause comes to your rescue. The idea is not to render it dysfunctional. The idea is not to waste time. The idea is not to carry out further exercise. But idea is not that with your eyes wide open you will walk into it. And furthermore, my lord, if the composition is defective, proceeding can still be initiated, and those proceedings will be set by the saving clause of section 93 to argue that where a commission...
So your argument basically is that
yes,
the saving clause will apply because this matter is a concluded matter.
Yes, not
and
only...
The next part is that it was before a competent...
It is to meet the contingency, exigency of the situation.
It was decided before a competent, body.
Yes.
Only thing is what happened, he resigned, fine. And so this won't come into play with that was a non-starter from the beginning.
Yes,
Plain
that's
and
it.
simple.
And another thing, my lord, because ultimately what? A member gets retired just before signing of the order, before the order is issued. It's an exigency. It is precisely for this very particular situation, saving clause of section 93 is there.
93 is applicable.
My lord, there is nowhere. I have read all that. Model code of conduct. Now, this another matter though, whether model code of conduct could have prevented the chairperson from signing the order is another matter. But there was a contingency not expected. It is precisely to meet this very kind of a situation we have a saving clause. My submission is there is no judgment on the authority that the saving clause under section 93 is to be pigeonholed or to be narrowed down to a particular context. No, only in that situation you will apply, in other situation you will not apply. Where do we get it? We don't get it. Logically, my lord, we can't come to such a conclusion. This is my submission. Now, my lord, interestingly, the Madhya Pradesh case was also referred to. It is along with the Waqf Board judgment that the Madhya Pradesh judgment was also annexed. This is 2023 SEC Online, Madhya Pradesh, 2717. Now, my lord, in fact, this judgment deals with the appellate tribunal. Primarily, the powers of the appellate tribunal. There are perimeter provisions, very correct. Learned counsel for the commission referred to it. I am grateful to him, my lord. Some of the very interesting research he has done, and I have seen some of these judgments which I could not lay my hand on earlier. Now, this Madhya Pradesh case, interestingly, primarily deals with the appellate tribunal. Provisions are perimeter. There, my lord,
yes,
section 30 of the act in the Madhya Pradesh case is perimeter to section 93. That, my lord, will find in the chart. In the chart is in paragraph 18. From para 18, the entire chart begins, and the chart continues, my lord, back portion just before paragraph 19 of the Madhya Pradesh case. Section 30, my lord, will see perimeter to section 93.
Vacancies, etc.
Yes, perimeter. Then, my lord, this along with, my lord, section 29, meetings of authority. It is perimeter to section 92 of the Electricity Act.
Proceedings.
Yes, my lord. Because I gave a particular interpretation to section 92, my lord would recall that. I will just reiterate, my lord, in my final sum up. Section 29 is perimeter to 92. So, though, my lord, this was not an issue and mention was made only in passing, it is an obiter dictum practically of the Madhya Pradesh High Court. Certainly not can affect this case because basic issue was appellate tribunal. We are not concerned with those very provisions. But while referring to section 29 and section 30, which is perimeter to section 93 and section 92, my lord will find the observation which is there in paragraph 21 of Madhya Pradesh High Court. What does the Madhya Pradesh High Court say?
Yes.
This court is also of the conceded opinion that section 30, which provides that any vacancy or defect in the constitution of the authority not to invalidate proceedings of the authority is in line with the provisions of section 29 subsection 2.
Now you see, come 29.2, you are the chairperson 22 of this, of this judgment, I mean 29.2, the section.
Yes.
If the chairperson for any reasons unable to attend the meeting of authority, any other member chosen by the members present
is unable to attend a meeting of the authority, another member. That is why the court says in para 21 is in line with the provisions of 29.2. Meaning thereby, because we are dealing with the saving clause. We are dealing with the saving clause in the context of section 29. Though this is not an issue, but an observation is made. That is all. That is all. Basically, the entire issue is appellate tribunal and powers of the appellate tribunal. We are not dealing with that over here. So how does it affect us? So practically, my lord, number one, if the composition is defective, proceedings continue before the defective, even if the composition of the board is, composition of the commission is defective, proceeding continues and proceeding attains finality or proceeding ultimately gets culminated, it shall not be invalidated because of section 93. Everyone agrees on that. There is no difficulty. The problem only arises when the argument is made that commission is properly constituted, it is not defective. Proceeding is initiated before a commission which is not improperly constituted, which is properly constituted. But just before it's attaining finality,
the person who heard didn't sign the order. That's all.
That's an area, my lord, over which there is no authority. But, my lord, logic and common sense will tell us we are in a far better footing than a previous situation, where the composition itself is defective from the very inception, and proceeding begins and continues. Because what is the idea? The idea is don't waste time. Let us not make it dysfunctional. Over here, my lord, determination of tariff is a very big exercise. A huge exercise was undertaken. Time was spent. People were heard. Finally, my lord, the person who was a party to the hearing issued the order. Other person could not do it because he retired in the meantime. Would it invalidate the entire proceeding? Would it not be said by section 93? That is the question, my lord, I am asking myself.
Anything else, Mr. Tiwari?
So, my lord,
that wraps up your point. Yes.
Now, my lord, it was also argued that appellate tribunal does not have power of judicial review under section 121. Yes, it doesn't have power of judicial review. There is no quarrel with this very proposition that appellate tribunal doesn't have power of judicial review under section 121. So the argument is appellate tribunal doesn't have power of judicial review under section 121.
Yes.
Power exercised under section 121 by the appellate tribunal is an administrative power. So therefore, well, commission should not follow it. I think this is the argument. Now, my lord, so far as judicial review is concerned, yes, section 121 doesn't give power of judicial review to appellate tribunal. For that matter, my lord, even section 111 does not give appellate tribunal the power of judicial review. What is judicial review, my lord? I ask myself. Judicial review is not an appeal against a decision, but it is a review of the decision-making process. It deals with an aspect of jurisdiction, whether there is an excess of jurisdiction in exercise of power, or whether the authority has acted without the jurisdiction, or whether the authority has acted with patent illegality or with material irregularity in the exercise of jurisdiction. That's the judicial review. That's the power of my lord. That is the power of the Supreme Court. Courts are vested with judicial review. Appellate tribunal is also not vested with the judicial review. In the PTC case itself, the Supreme Court said, appellate tribunal cannot strike down the regulation. It doesn't have power. Naturally, it will not. But, my lord, the question is, merely because an order issued under section 121 of the Electricity Act 2003 is an administrative order, is it not binding on the commission? Well, the Supreme Court says to the contrary. And that those Supreme Court observations are inbuilt in this very particular case of PTC India. Raman versus Raman authority has been referred to of the Supreme Court to reiterate the principle that such an administrative order shall be binding on the authority. I'll come to that. Let us look into PTC India Limited, 2010 4 SCC. (603). Relevant para is paragraph 82, where Raman is referred.
Is it given a compilation?
My lord, PTC is there in the compilation itself. PTC, my lord, will find. That way, my lord, I am grateful to both my colleagues. They have been of immense help. Because over here, my lord, certainly we could not do it in a proper way. PTC is in second volume. I am grateful to my colleagues. They brought all the judgments. Second volume, serial number 5. PTC India Limited versus ERC. Here, my lord, naturally, I will have to show, my lord, what has not been shown to your lordship. They are relying on paragraph 50, 54 to 57, 92.
Paragraph 47.
Yes. My lord, yes. I will have to refer to something which was not shown, naturally. So let us turn to, my lord, paragraph 82. PTC India Limited. Before that, I start with paragraph 81.
87.
My lord, 2010 4 SEC, para 81 and 82. 81 and 82. I hope all the pages are here.
Yes.
I'll just, yes.
Raman, yes. 81.
I'll start with paragraph 81 of PTC India.
Yes.
In Raman and Raman Limited versus State of Madras, Section 43 capital A of the Motor Vehicles Act 1939 as amended by Madras Act 20 of 1948 came for consideration before the Supreme Court. Section 43 capital A conferred power on the state government to issue orders, quote unquote, and directions, quote unquote, as it may consider necessary in respect of any matter relating to road transport to the State Transport Authority or Regional Transport Authority. The meaning of the words, quote unquote, orders and directions came for interpretation before the Supreme Court in the said case. It was held on examination of the scheme of the Act that Section 43 capital A was placed by the legislature before the sections conferring quasi-judicial powers on tribunals, which clearly indicated that the authority conferred under Section 43 capital A was confined to administrative functions of the government and the tribunals rather than to their judicial functions. Then comes the paragraph 82. It was further held in Raman and Raman Limited that the legislature had used two words in the section. One, orders, and two, directions. Both the expressions, my lord, will find in section 121. This court further noticed that under the 1939 Act, that is, my lord, Electricity Act,
yes,
there was a separate chapter which dealt with making of rules, which indicated that the words orders and directions in section 43A were meant to clothe the government with the authority to issue directions of administrative character. It was held that the source of power did not affect the character of acts done in exercise of that power. I repeat, my lord, the source of power did not affect the character of acts done in exercise of that power. Whether it is a law or an administrative direction depends upon the character or nature of the orders or directions authorized to be issued in exercise of the power conferred. It was therefore held that the words orders and directions were not laws. They were binding only on the authorities under the Act. This is important. They were binding only on the authorities under the Act. So, my lord, Commission is a statutory authority under the Electricity Act of 2003. The administrative orders under section 121 was issued by the appellate tribunal. It was binding on the Commission. Now the question is whether the Commission would follow this very order of 3 members, or it will follow, my lord, those orders given in a list between the two parties. It was argued, oh, that is an appellate order, you see, under section 111. You are bound by that. My lord, the argument is absolutely incorrect. For the very simple reason, my lord, these are general directions given under 121. And as to whether it is a law or only an order or a direction has to be seen from the nature of the order. The court says so. My lord, in 121 order, the legal position has been explained by the appellate tribunal. It was binding on the Commission. If the Commission found that in a list between the two parties, in exercise of appellate power,
yes,
in exercise of appellate power, if certain orders have been passed which are contrary to this very direction under 121, Number one, my humble submission is Commission ought to have followed the order of the larger bench, number one. Number two, if Commission was still confused as to what is to be done, because 121 order was a general direction to everybody. This direction was issued after hearing the commissions all over the country. They were party to it. And these directions were given. And my lord, though those appellate orders are concerned, under section 111, Jindal case and etc., they are the issues between this between the two parties. Practically order in personam. This is the RAM direction. So, Commission had two options. Either you go before the appel and say, well, here is a conflicting situation. Should we follow this or should we follow that? Let the appel decide. You didn't do that. You took upon yourself. You usurped the jurisdiction and you decided you will not follow the direction of the Commission.
Yes, usurped jurisdiction. That's what you say.
This is what I'm saying. You usurped the jurisdiction.
Okay.
You took upon yourself to decide what you should follow and what you should not follow. You could have come before the Honorable Court. You could have taken guidance from the Honorable Court what is to be done in this very kind of a situation. You did neither. You followed a better course because you knew the outcome. You knew it beforehand.
Anyway, okay. Is there anything else?
Then, my lord.
Yes.
So, I have repeated, my lord. Again, I will speak only one sentence. Gulla Parli has no application. If at all, just one paragraph, they are relying on that paragraph. I will bring that paragraph to my lord's notice. They are relying on it. Gulla Parli, my lord will find. I have no quarrel with the principle laid down in Gulla Parli. I can't have any quarrel. That's a correct principle. But whether that principle can be applied here. Gulla Parli, my lord, in the compilation of the Commission, serial number 6. Page 44, Gulla Parli judgment begins. Relevant para 31. They have quoted it. Para 31.
Yes.
Para 31, my lord will find. (16:9) 31. Yes. Page 70 here in my compilation. Para 31. I'll just read this. They are also relying on it. The second objection is that while the Act and the rules framed thereunder impose a duty on the state government to give a personal hearing, the procedure prescribed by the rules impose a duty on the Secretary to hear and the Chief Minister to decide. My lord, I repeat. Procedure prescribed by the rules impose a duty on the Secretary to hear and the Chief Minister to decide. This divided responsibility is destructive of the concept of judicial hearing. Such a procedure defeats the object of personal hearing. Personal hearing enables the authority concerned to watch the demeanor of the witnesses and clear up his doubts during the course of the arguments. And the party appearing to persuade the authority by reasoned arguments to accept his point of view. If one person hears and another decides, then personal hearing becomes an empty formality. We therefore hold that the said procedure followed in this case also offends another basic principle of judicial procedure. I submit it is no application, my lord. There is no quarrel with this principle.
That's it, Mr. Tiwari.
My lord, lordship, yes. Bear with me, my lord. May I, my lord, because this is a very important case, my lord. I have to, there is something more is left.
Yes.
May I continue, my lord, or may I make my submission after the lunch, subject to whatever my lord would. I will take half an hour more. Within half an hour, I'll finish everything.
Then what about, I don't think any more reply is necessary.
My lord, there can't be a reply to the reply. This is not the very well.
Once you bring up new points of arguments, Mr. Tiwari, you're not famous.
Preliminary objection that was not argued. Now he has submitted something in counter. So
right.
I have a right to rebut that.
Oh no. We'll give you a right. No, we understood that because he has, has developed his case. Now he's, fashioned it in different manner. He has come, with a remodel argument today.
I can't presume things from the very beginning.
So, yes.
The visibility on the respondent side would be, I will just put it very simply, that my esteemed senior had not started with how the writ was maintainable, and then in reply he's dealing with all the arguments on maintainability of the writ petition. We have raised it as an objection and a counter affidavit.
No,
Both
to
about
that he has submitted the other day that because when Advocate General started his arguments, maintainability was not.
I made it very clear in the very beginning.
Yes.
I said if the arguments are made on maintainability, just because it is there in the affidavit, just because it is in the affidavit doesn't mean that I will say something in the very beginning.
He chose not to reply.
Yes.
Because things are in the affidavit, all right, but unless and until you argue and
Fine.
we have all been trained.
Let's not get agitated over that point. Is already over.
This is quite fantastic.
Yes. So anyway, I will give you another.
In half an hour, I'll finish.
After lunch.
Very well, my lord.
Yes.
after lunch. Blind.
Yes. No other matters for this thing.
Second for item 8. Item 8.
Yes, an application for vacating the interim orders here.
Lordship, we had filed our application.
When was it filed?
It was filed on 18 February, Lordship.
18?
18 February.
Yes. On 19th.
On 19th, the matter was
19th,
listed.
you sought time for application. You didn't file a objection.
But we are almost on the verge of completion, my lord. I will just take 1 week's time, my lord.
To do what?
To file a show cause to the.
Now 2003 is operating. See, you asked for that's 19.2. Now it's going to be 2 months.
Not
19.2. You sought time. See the order.
Right, my lord.
Right.
I'm praying for a week's time, my lord. I think that will suffice.
Lordship, they had approached this court.
This is the second time, my lord. This is the second time I'm seeking.
They have not disclosed this document and obtained a stay order, Lordship.
No. I have already submitted, my lord. We were never privy to this document in the first place. In fact, even the government was not privy to this document.
Yes.
We are saying, my lord, this document is a result of an afterthought. My lord will see the annexure 14 first. Annexure C, page 14.
Oh, the minute petition.
No, my lord, the show cause. I mean, the
miscase.
Miscase.
Annexure with a miscase. Yes. Yes.
Now, my lord, here they gave a reason why this order is passed. Now, my lord, after 11 days, my lord, 11 or 12 days, they pass another order.
But they
Here they don't give a reason.
The thing is that whatever it is, you have to acknowledge now what will be the outcome. The fact remains a competent authority. First kept in abeyance, then after they say, okay, let it go on.
No,
so
my lord,
how can you hold them accountable?
My lord, the reason why this order was kept in abeyance is because, my lord, there's an inquiry pending as against this very managing committee.
What about this 11 December where he said let it go?
No, there has to be some reason. My lord, may kindly see. Today, your lordship passes an order.
New order.
We'll challenge, my lord.
You have not come with it after this case was filed. It's come to your knowledge. You have not filed an objection also.
Well, we'll file an objection, my lord. That is why I'm praying for a small accommodation, my lord. Week's time will suffice.
Lordship, the locus of the petitioner is also.
No, locus. I have a locus. I'll satisfy your lordship on that.
He's not even a candidate.
No, I need not be a candidate, my lord.
Wednesday. Yes,
let him file the objections.
We'll file the objection.
Matter stand adjourned to.
Let it be on Thursday, my lord. Wednesday, I have some problem.
Okay, Thursday.
Lordship.
Yes, on the application for the miscase for vacating fixed for hearing. Objections will be on board before the next date. Yes.
Obliged.
Yes, Mr. P.T. Sama.
Item number 30, Your Lordship, I humbly pray that this matter may come after 2 weeks.
Why?
It is for hearing, actually. It is for hearing, actually.
Then we'll hear it after we conclude other matter. We'll hear it. 30.
I have some.
Why? You want to go home and sleep?
No, Lordship. Some appointment in this to check.
Appointment with whom?
With doctor by around 2:30 like that.
So you tell your junior to call the doctor to extend the appointment. What's the matter about?
This is actually termination. It's amount to termination.
Your Lordship, Mrs. Yang is appearing in this matter.
Okay, 30 after 1 week then.
Lordship.
Manshu here.
Certainly.
Item 28, you mentioned.
28 we've been it's passed for the time being. Or which one's the matter with us?
No, Lordship, this is 28 on behalf of AH Karwan now.
28.
28.
Who's there for the petitioner?
I'm
You ready with the matter?
Yes, we are ready.
You ready?
Yes, sir. Lordship, after 2 weeks.
Why? Because you should have mentioned at the beginning why you made them wait then. You'll pay a cost.
No, Lordship.
No, you won't pay cost. Who's leading you? You're doing yourself.
No, Your Lordship. The conducting is another court, Your Lordship.
Okay, when is Mr. Karana coming back? Should have adjourned. They're seeking time. You have objection?
No objection, Lordship.
Okay, after 2 weeks, yes. As the Conduct Council, Karana is not present. Mr. Jha, I'll wait for his matter. Jaichan Kumar. His matter is nearly already heard, correct?
Heard, Your Lordship, but then the petitioner has filed an additional affidavit, Your Lordship. The petitioner has filed an additional affidavit, Your Lordship, in this matter. So, Your Lordship, we're still waiting instructions from the department, Your Lordship.
Regarding competency of the person who has awarded the
14 years request.
Punishment here. Is MS Argurung please that the matter be adjourned as instructions still waited and additional affidavit filed a petitioner. This ought to we'll finish this off. So we'll get the
Yes, Your Lordship.
Yes.
I would not take much time of your lordship. I'll finish it up, my lord, in 10 to 15 minutes. I'll be very, very brief. Now, my lord, on a principle that judgment is only an authority for what it actually decides and not what can be logically deduced from it, there is a beautiful passage of Lord Halsbury in Quinn versus the Leathern, which was, my lord, recently, in fact, relied on with approval by the bench of the Supreme Court presided by Justice Pardiwala. My lord, that is not yet a reported case, but my lord, the same passage was quoted by Supreme Court. Yes. My lord, I'm showing that the same passage was quoted by Supreme Court with approval in 2013, volume 15 SEC. That is Ars Meta versus Lafarge India. 2013, volume 15 SEC, page 414. Paragraph 32 to paragraph 34. 32 to 34. The passage from Lord Halsbury, my lord, will find in paragraph 33. They have referred to here only as Quinn. It is Quinn versus Leathern. Very recently, my lord, a few days ago, I would not read the principle, my lord, it is there. How judgment is to be read, understood, and to be applied to cases before the court. (32 to 34). In Ambika Query Works for State of Gujarat, it has been stated that the ratio of any decision must be understood in the background of the facts of that case. Relying on Quinn versus the Leathern, it has been held that the case is only an authority for what it actually decides and not what logically follows from it. Then the passage comes in para 33, yes, followed by para 34. It's a well-known principle, my lord. I would not take much time. So thereafter, my lord, I will just touch upon some of the issues raised in the reply of the London Council appearing for the public utilities. It was argued that tariff order has not been challenged on merit. Rightly so. We are not required to challenge the tariff order on merit. For merit, then we have to go to the APTEL. Here, my lord, the very basis of challenging the tariff order is that it is a creature of an action which is either in excess of jurisdiction or suffers from inherent lack of jurisdiction. But for the order of recall, the impugned tariff order would not have come into existence. So precisely on that ground, the tariff order is under challenge, not on merit. We are not required to. Then it was also argued, yes, that under section 92, when the order was issued finally, when the order of recall was when order was issued by a single member, there was no appropriate commission because there was no chairperson.
That's important, yes.
When single member issued an order of tariff at the relevant point of time, there was no appropriate commission because there was no chairperson. Without a chairperson, there cannot be appropriate commission. This was argued. For that, my lord, I will counter it by placing reliance on the provision itself, section 92. Section 92, subsection 2 and 3, lordship may see for a moment, of Electricity Act.
Yes.
Subsection 2, section 92. Subsection 1, my lord. Anyway, let us read from the very beginning itself, 92. Subsection 1, the appropriate commission shall meet at the head office or any other place at such time as the chairperson may direct, and shall observe such rules of procedure in regard to the transaction of business at its meetings, including the quorum at its meetings, as it may specify. My lord, in my initial arguments, I had given my understanding and interpretation of subsection 1 itself. Lordship may recall that. In my bullet points, I will write that. Now subsection 2 comes. The chairperson, or if he is unable to attend a meeting of the appropriate commission, any other member nominated by the chairperson in this behalf, and in the absence of and in the absence of such nomination, or where there is no chairperson, Lordship may kindly take note, or where there is no chairperson, any member chosen by the members present from amongst themselves shall preside at the meeting. Then next, subsection 3, all questions which come up before any meeting of the appropriate commission shall be decided by a majority of votes of the members present and voting, and in the event of an equality of votes, the chairperson, or in his absence, the person presiding, shall have a second or casting vote. So that is it, my lord. Subsection 2 or subsection 3, subsection 2 clearly said there is even a possibility that there is no chairperson, either absence of chairperson or there is no chairperson. Both the words have been used. So it is not that just because chairperson is not there or chairperson is absent, there is no appropriate commission. Of course, my understanding and my interpretation of the entire scope of section 92 is that section 92 pertains to the in-house proceedings and the meetings of the commission. It deals only with that and nothing more.
All meetings. Yeah.
That's all. But even in that case, my lord, merely the absence of chairperson or there being no chairperson would not ipso facto will lead to dysfunctional of the commission. Commission would not be rendered dysfunctional. So statute is clear. Then, my lord, section 93, referring to section 93 of the Electricity Act, it was argued that section 93 cannot be drawn into quasi-judicial proceedings. That section 93 has no, saving clause has no application in respect of quasi-judicial proceedings. My lord, I ask myself, where do we get it? If that be so, my lord, then you set aside the Supreme Court judgments also. The Supreme Court itself says, if the commission is improperly constituted, the proceeding before such a commission shall not be invalidated because of the saving clause. So therefore, my lord, this is not a correct contention. Determination of a tariff, my lord, even if it is a quasi-judicial proceeding, it is protected by a saving clause. Then, my lord, it was further argued that section 82 subsection 4 mandates that commission must have 3 members.
Yes.
So if the 3 members are not there, again, possibly the argument was there is no commission. Let us have a look at section 82 subsection 4. Straight away, my lord, subsection 4 itself we can see. The state commission shall consist of not more than 3 members, including the chairperson. Upper ceiling is there, and section 82, my lord, ultimately has to be read along with section 92. You can't give a truncated reading and meaning to a particular section in isolation, ignoring, my lord, the other provisions. So it has to be construed harmoniously. Section 92 itself envisages a situation where there is no chairperson. Then, my lord, I have already dealt, section 121 is an administrative power. I have dealt with it, referring to PTC India. It is binding on the commission. Section 92 subsection 5 was referred, and it was, referring to section 92 subsection 5, my lord, the argument was orders have to be authenticated by officers of the commission.
Or authorized by the commission.
Yes.
Authorized by the chair.
Authorized, or that is it. Now, my lord, simple. The argument is, even one of the member can act as a chairman, or even if the chairperson is not present, the meeting can continue. In any case, my lord, the saving clause will come into play. So, the argument 92 subsection 5 may kindly be seen for a moment.
All orders and decisions.
All orders
and
decisions of the appropriate commission shall be authenticated, yes, by its secretary or any other officer of the commission, duly authorized by the chairperson in this behalf. Now, my lord, 5 has to be construed harmoniously with subsection 3 and subsection 2 of section 92. Section 92 itself says there may be a situation where even a chairperson may not be there. If the chairperson is not there, my lord, where is the question of chairperson authorizing the officer to sign? I ask myself. But, my lord, all said and done, I again submit, section 92 relates to the meetings. And whether, my lord, Section 93, the saving clause is open-worded and why didn't it sweep? I reiterate my submission. It is applicable both to Section 92 as well as, my lord, to the proceedings in respect of determination of tariff. Saving clause is wide in its sweep.
Yes.
So we have to construe harmoniously. Then it was argued there is no challenge to the regulation. Regulation 9 is there, Regulation 10 is there. My argument is very simple. We should not challenge the regulation. We are not concerned with the regulation. Regulation has to be construed harmoniously with the substantive provisions of the Act. That is all. And in any case, my lord, those very provisions of the regulation I have given my own interpretation in my submissions earlier. Namely, my lord, those provisions of the regulation relate to, my lord, the meetings of the board. So, my lord, finally, I will only sum up, reiterating my earlier submissions with a little modification. Firstly, I will give the bullet points, my lord, in writing on this. No quorum has been provided for under the Electricity Act of 2003 for proceeding before the Commission under Section 94, 95 and 86. Proceedings in respect of 94, 95, 86, there is no requirement of any quorum. No quorum is provided for. Even a single member, my lord, is authorized, is competent. He can do it. Secondly, quorum is spoken of under Section 92 and Regulation 10 is in respect of meeting of the Commission for transaction of business. And such meeting has to be conducted in terms of Regulation 9. It's board meetings.
Yes.
Thirdly, assuming without admitting that quorum is provided, or there is any defect in the quorum, either at the initiation of the proceeding or during it, it shall be protected by saving clause. The proceedings will be protected by the saving clause. Why didn't it sweep?
Okay.
Fourthly, proceedings of the Commission under Regulation 8, sub-regulation 1, 2 and 3 is in respect of meeting of the Commission for transaction of business. Same thing. Fifthly, so far as Regulation 8, sub-regulation 4 is concerned, it is nothing but a verbatim reproduction of Section 95. Section 95 says, in a limited context, the Commission has trappings of a court.
Before Commission is.
So, it's nothing verbatim reproduction. So, Regulation 8, sub-regulation 4 does not improve their case. Section 95 is there. It has to be understood having the same scope as that of Section 95. Sixthly, requirement of signing of the orders by all of those, that is chairperson and members, who hear the matter under Regulation 18, sub-regulation 3 has to be read in harmony with Section 93. Regulation 18, sub-regulation 3 has to be construed and read harmoniously with Section 93.
Saved.
Yes, and not to defeat or negate the very objective of Section 93. Because the very scheme of the saving clause is not to render the Commission dysfunctional. Time has been lost, my lord, in carrying out the whole proceeding. Why do you do away with the whole thing? That is the objective of saving clause. Then, my lord, seventhly, Commission is the direction of APTEL under Section 121 is bound on the Commission. Commission was bound by it. That is PTC India Raman versus Raman, Para 82. That is a proposition. If you had doubts, either go to APTEL or come before the Honorable Court. You could not have gone to Commission.
Yes.
Then I had argued this earlier, my 8th submission, namely, regulation having been made under Section 181 subsection 2 ZL and section 92 of the Act must be limited to the scope of the subject it is made under. It can't travel beyond that. But I need not challenge the regulation. My lord will harmonize it with the substantive provisions of the Act. Last but not the least, the last submission will follow thereafter. Regulation cannot be read and understood in a manner to negate or defeat the substantive provision of the legislation.
Yes.
It must serve the objective of the legislation and not defeat it. And lastly, my lord, good law party has no say. No violation of the doctrine that one who hears must decide. That doctrine has no relevance in the case.
You say so?
Yes. Because the good law party judgment has to be tested on the touchstone, my lord, of the principle, well-known principle, that judgment is only an authority for what it actually decides. My lord will apply the principle of Quinn versus the Latham, Lord Hawkesbury dicta, quoted so often by the Supreme Court in various pronouncements. My lord, I rest my case here. And my lord would lastly remember and would recall the retrospectivity, my lord. I had touched upon that in my earlier submission. The retrospectivity. It could not have been retrospective, the tariff order. And my lord, finally, my lord, as and when the judgment of my lord comes, in the intervening period, my lord, we have a real worry. My lord, we will continue to pay the current tariff. They should not take any coercive actions on us.
The thing is that we have the problem with in the other matters, because at least as they given us.
My lord, at least we are not responsible for that.
You have covered everything. I
So,
mean,
my lord, my only worry in the intervening period,
anyone
my
can
lord,
expand or add or
bullet points I will give. I will not.
No one
and my
will
lord,
add to your argument.
and my lord,
I mean, you've got traverse.
I will give the bullet points. And my lord may recall, my lord, we all have undergone that kind of a training. My lord, in the Guwahati High Court, this was always the practice that if there are issues involving the maintainability of the writ petition, the Honorable Court would always tell us, if respondent is raising an issue of maintainability, respondent will argue the case first. Always. So, one may press it, one may not press it. So, once it is pressed, answers are given. So, naturally, I'll have to modify my arguments accordingly. So, my lord, only during the intervening period, my lord, current tariff we will pay, no coercive measure for recovery of arrears. Lordship may protect us to that extent because there is a serious threat. We are being repeatedly told, because there are instances galore when they ended up cutting the electricity and no assurance has come from the other side that they will not resort to such tactics.
Yeah, Mr. Arfi, any replies
yes,
now?
Yes, my lord. Your lordship, the first and foremost point which has been raised by learned senior counsel is that the tribunal, the commission is neither tribunal nor court. And therefore, proceedings before the commission, my lord, is not in the nature of tribunal, and therefore it has no inherent jurisdiction. It can't go into all the issues, my lord. That is what the first point is, my lord. If your lordships would recall, my lord, that I have specifically laid emphasis on the judgment of the Honorable Supreme Court in Jaipur Vidyut Vitran Nigam Limited, my lord. My friend will hand over. My note, my lord, note of final hearing. That note, if your lordship, because that will cut short my argument, my lord. It's in bullet point form only, my lord. Kindly see serial number 1, my lord.
Yes. You give a copy the other side?
Yes, I'll hand over a copy, my lord. This is this is what I have argued before your lordship, my lord. That is the same thing, my lord. If your lordship will kindly see Jaipur Vidyut F, the judgment at serial number F, my lord, and judgment at serial number E, those judgments have not at all been adverted to or touched. E and F, my lord. F is the judgment which I have relied, which is specifically on that issue, that in these matters, the alternative efficacious remedy is the remedy in law, my lord. What was argued before your lordship that you have are exercising writ of certiorari, and in case of writ of certiorari, in case
But
of
in your compilation,
prohibition,
but these have come in compilation 2. The compilation 1, you relied on the judgment of this court and South Indian Bank, right? Yes. In the when you made the arguments, compilation 2 on discontinued remedy. So you're not relying on your that means you're going to place your emphasis only on this PHR invent and Jaipur Vidyut Vitran Nigam. Mr. Advocate General, please unmute. Unmute. Not audible. Please unmute. Just message him.
I've messaged him.
Yes, okay. What's happened now?
Sometimes.
Am I audible?
Yes, now you're audible but not visible. Yes.
Initially you were visible but not audible. Now you're audible but not visible.
Yes.
Mr. Venkatesh has come.
Getting correct.
So Mr. Tiwari's submissions have
Network
made him
network
inaudible
has
and now invisible.
Network has raised a preliminary objection. Network has raised a preliminary objection on the counter argument of Mr. Kumar.
Yes. Let him rejoin.
May I take leave for 5 minutes, sir?
Please.
Am I audible now, my lord?
Yes.
I'm sorry, my lord.
No problem. Yes.
My lord, if your lordship kindly see my first point, availability of alternative efficacious remedy in appeal, my lord.
No, that is considered. Yes, okay.
Yes, my
Then
lord.
inherent
And
power
then,
was.
And Jaipur Vidyut Vitran Nigam Limited has not at all been adverted to, not referred, not a single line, my lord.
Yes.
Now, the second thing is, my lord, section 64(6) has not been adverted to or referred to at all.
64(6).
No reference of section 64(6). Your lordship kindly see section 64(6).
What does it say?
It says that the tariff order, unless reviewed or recalled or modified. So my case was, my lord, unless amended or revoked or continue to be enforced.
Yes.
So there is an inherent power.
Yes.
There is an inherent power. This has not, I have dealt with that, my lord. And it has not been adverted to.
Yes.
Now, if your lordship will kindly see what is being said under section 111. 111 has been read out to your lordship.
No, but argue the same arguments again, I hope.
No, I'm not. I'm just dealing with the submissions of my learned senior.
Pandey will give you bullet points. Yes. Be better also. You can see instead of yes.
Your lordship kindly see section 111.
Yes.
I will deal with that part only, my lord.
Yes.
111 says any person aggrieved by an order made by an adjudicating officer under this act or an order made by appropriate commission under this act may prefer an appeal. So what was highlighted to your lordship is that an order made by under this act.
Yes.
And what was said that there is no power under the act to recall or to declare its own order non-est, because there is an order passed by a bench or person hearing the matter, because that argument has, one who hears must decide argument has been given up, my lord. To an extent, earlier entire emphasis was that member judicial, not member legal, has heard the matter and he has decided the matter. If your lordship would recall, the entire emphasis.
No. Now Mr. Tiwari is rebuttal whole arguments. Today is like fresh arguments are made again.
That is the problem. That is why
I was hearing him, for.
My submission is that my learned senior counsel has given up his argument on that point. He says that no, now the defect has
He
been
said it does not, the order is not an order passed under the act. It's outside the purview of the act, ambit of the act. And so it's not under the ambit of the act, and so there's no appeal provision available before appeal. And so we have to come for this court. That's what some substance. Yes.
Yes, my lord. Yes, my lord. So what now?
I have to show that it's an appealable order. That's what it comes to four corners of the ambit of the LSV Act.
Yes, my lord. That is what, and for that, what I have showed, my lord, 3 judgments. My lord, if your lordship will see serial number 2 of my note, serial number 2.
Greater Noida.
Now your lordship will power of recall is inherent. First, section 64(6), my lord, kindly provisions which I have referred to. 86.3, 92.5, 174, and conduct of business regulation 2126, my lord. In serial number B, if your lordship of my note, the conduct of business regulations 2021 and 26.
Where does it come from?
It comes from, my lord, if your lordship will kindly see conduct of business regulations.
Okay.
And it comes from MYT regulations, my lord. MYT regulation is the regulation.
Yes.
If your lordship will kindly see the page serial number, the compilation number MYT regulation, my lord. If your lordship will see MYT regulation in my compilation, my lord, in the first volume, my lord. First volume at page.
Yes, 10.
10, my lord. So this is the entire thing has been carried out, my lord. If there is a quorum, MYT, so what is being asked by your lordship? Please ignore these regulations because they are inconsistent with the act.
Yes.
Please, because since the regulations are
and even that, you see, even that's one thing. Even Regulation 26, there's been argued that Regulation 26 militates against the Parent Act. And so we meditate to that extent of how it offends the Parent Act. It should be has not been a submission, but effectively that this court reads down that provision as it cannot have overriding effect on the Parent Act. So that is what has been argued, if I correctly understand.
No, today it is not reading down, my lord. Today it is a harmonious construction. Yesterday, when on the first day it was reading down.
Okay.
When I raised the objection. Now, your lordship, the harmoniously, your lord, what is the task which is cut out for your lordship as per the learned senior counsel is that now your lordship will harmoniously construe, and harmonious construction means ignoring all these provisions because it is inconsistent with the act. My lord, it is a tall order in my humble submission which is being asked. These regulations are consistent with the act. These regulations are not under challenge. If your lordship will see that, and I have cited the judgment, that regulations, if your lordship will see the page 10 of my compilation, page 10 of the first compilation.
Yes.
First paragraph, first page 10 of the compilation. In exercise of power conferred by clause Z so and so.
Yes.
Yes, my lord, compilation number 1, my lord, under subsection 2 of section 181, read with section 61 and section 62, this MYT regulations have been made. And MYT regulations, my lord, is very clear that the commission has to follow the process of this commission has to follow regulatory commission conduct of business regulations, my lord. They cannot decide the matter without following the regulatory commission. And I have already shown, and your lordship has already referred these points in your lordship's earlier order, that 9, 10, 18, 21 and 26 are mandatory. What has been argued today is that your lordship has not laid down the law by directing the parties to follow these regulations, my lord. Your lordship has considered the matter, thought it proper, and thereafter order has been passed. This is not the way to distinguish, in my humble submission, the judgment of an order of this honorable court, which has been upheld by the division bench also, my lord. Division bench has laid down these three parameters, my lord. Now every order, your lordship has seen three orders passed by the commission. Three orders where
Yes, your lordship, just to assist, page 13, regulation 15, in the same regulation 15 at page 13.
15.1, yes.
Yes, 15.1.
The proceedings to be held by commission for determination of
Shall be as per the regulation.
Yes, my lord, 2007. And admittedly, it has not been done when in the June order was passed. One who hears must decide. One who hears, division bench will hear, single judge will decide. That is no hearing in law.
You just keep the bullet points, these things, because I marked it earlier in the MIT.
Yes, my lord. That is,
but then to collate all of it, maybe it might escape me.
Yeah. Yes, my lord. That is what now your lordship will see. They in serial number 2, Greater Noida Authority, my lord, inherent powers, Srei Infrastructure, serial number 2D, my lord. Yes. And my lord, and three exercise of recall is not wholly without jurisdiction. Within Bhadra also says it is within the jurisdiction, my lord. Now kindly see the note. Petitioner admits power of recall exists in MSCRC. My lord, this was the argument when I prepared the note. Then on the second day it was argued, no, I could lay hand on the proposition, therefore I did not argue this point. With greatest respect, my lord, everybody knows that proposition is clear. From law, everybody knows, my lord. My friend has conceded. He has taken U-turn after I commenced my argument that this is the admission and this is the error within the jurisdiction, not outside the jurisdiction. Then my friend argued, no, I just want to place two authorities on that proposition. My learned senior counsel is a seasoned counsel, Lord, with experience. He would not simply wait for the authorities to argue the matter. He was trying to fill the lacuna in his own argument. But the exercise of incorrect single is a valid legal order. This is not a case of quorum non judice, as the present proceedings are proceedings of commission which are administrative nature now. Now you will also kindly see what has been argued, that look, only limited civil power is there with the commission below. They are not quasi-judicial, they are not administrative. I don't know what is the legal structure. But these issues are no longer germane, my lord. Kindly see one judgment, my lord, at Tamil Nadu at serial number 6 of my second compilation, Tamil Nadu judgment, my lord.
Tamil Nadu generation distribution?
Yes, my lord. Tamil Nadu generation distribution as serial number. Because 6. I prepared the note suddenly. Every day I come out across with new argument. Paragraph 55, my lord, at page 188 of the Tamil Nadu, my lord.
Yes. Para 50 and para 59.
Para 55 at page 188, my lord.
We however find substance. You only read it.
We however find substance in the submission of Mr. Nariman that adjudicatory function generally ought not to be conducted by a state commission in absence of judicial member, especially in relation to disputes which are not fairly relative to tariff fixation or advisory.
But this deals judicial member out here. This member law, this Mr. Soni, whatever, he's the judicial member, correct?
And there is, see, lordship, judicial member and technical member. There are two members.
No, correct. No. Here this judgment says that fine substance submission that ought not be conducted by state commission absence of any judicial member. So in this case, judicial member was there.
No, yes, legal member was there. I have no dispute with this proposition, my lord. But when it comes, because this judgment says that legal member presence is required, but technical member presence is because it is a adjudicatory body on technical aspect, my lord. Kindly see the 56. A constitutional bench of this court in Kyoto, Holohan, has examined the nature of power of the speaker or chairman under paragraph 6(1) of the 10th schedule constitution, which contains provisions of disqualification on ground or restriction of a member of either house upon consideration of entire matter. It was observed. Power in the present case, power to decide disputed qualification under is preeminently judicial complexion. The constitutional bench in relied on earlier judgment of this court in so and so. By court is meant courts of civil judicature, and by tribunal those bodies of men who are appointed to decide controversies arising under the special law. So this is those bodies of men who are appointed to decide controversies arising under the special laws. So this is a special law which under the adjudicatory function is there, my lord. Among the powers of the state is included power to decide such controversies. This is undoubtedly one of the attributes, my lord. And kindly see next paragraph 58. Again in para 99 it is observed as follows, Kyoto Holon, where there is a list and affirmative by one party and denial by the another, and dispute necessarily involves a decision on the rights and obligation of parties to it, the authority is called upon to decide, and there is an exercise of judicial power. That authority is called tribunal. And it does not, if it does not have all the trappings of the courts, it is a tribunal. What was argued by my friend, my lord, before your lordship, it is not a tribunal. Therefore, it's not an appealable order. Paragraph 59 in view of
no, yes, I remember this, Holohan, because it's just whether the speaker can be a tribunal. And this is like there was a landmark case, yes.
That was the landmark case, and that landmark case shows, my lord, that you may not use the word tribunal. It's a commission, but it is really exercising the power of tribunal. It is a tribunal in true sense. And commission is also a tribunal. What was argued before your lordship is that commission is neither tribunal, it is an administrative authority. If it is an administrative authority, it has the power to review. If it is a quasi-judicial authority, it will do it in accordance with law. But my friend is saying, no, it has got limited power of civil court only in case of perjury. Otherwise, it is not deciding a dispute between the party. It is not doing anything. I don't know. I couldn't follow the argument below. 59.
No. But Mr. Tiwari's judgment grounded on one thing, that the order passed is not within the ambit of the Act. That is all. And so, if it's not within the ambit of the Act, like, whatever has happened, forget about it. It's not ambit of the Act, so it's not appealable. That is all.
Yes,
that is what he says advance. Yes.
To my friend,
so those other side arguments like power of civil court and so on and so forth.
Lordships have got ample experience. On first day, my friend conceded that the commission has the power to recall its order.
Yes.
On the first day, it was the argument. I said that now my task is very limited. My friend has conceded that he has the commission has the power to decide the matter, and it is inherent to it. Then I made 45 minutes of submission. On next date of hearing, my friend came, no, my lord, I could not lay hand on the judgments. Therefore, this is with greater disingenuous submission, my lord. Because you know that the commission has the inherent power. And you are trying to move away from your stated position which you took before, because nowadays everything is on YouTube, my lord. Your lordship can review the argument, my friend, my lord. This is disingenuous argument, my lord. I have not come across. Once I say before the court, and then I come out and they say, no, there is no jurisdiction in the court. I am taking my argument back, because it is an argument in law. I can take this argument back.
I did not know that the submission of a lawyer is barred by res judicata.
Yes, my lord. That is the
okay. Let us not digress to that. I mean, just finish. Let's complete.
I'm sorry. Yes, my lord. So the question is, my lord, whether the commission has power or not, my lord. That is answered by not by this Greater Noida Authority judgment, Srei Informed, and Jet Plywood. 3 judgments I have placed. Now, what is the argument? If you have confusion, you go before the appellate tribunal. I have no confusion. Confusion is with you. You go before the appellate tribunal, and then you get the matter decided, because under 111 appellate tribunal has been constituted for that only. I have no confusion. Why should I have confusion? Law is clear. The order was non-est, and therefore it was recalled. And that is the stated position on the first day of argument that yes, the commission has power to recall its order.
Okay.
And the act also provides, my lord, the commission has power to recall. Now, what is being argued also, my lord, that this lacuna, the quorum issue, etc., the quorum is because yes, this deficiency can be cured by reading the Electricity Act by saying that no, the vacancy, etc., is there. Your lordship is aware, my lord, if the matter is heard by 2 or 3 or 4, the decision has to be 3. This provision, my lord, I need not refer that provision also to show that the vacancy because not more than 3, and if the commission is sitting with and 2 members are deciding the matter, then that provision will save the hearing of the commission because there is a vacancy of 1, my lord. It is not vacancy arising out of retirement of a judge, my lord. It's like, my lord, division bench has heard the matter and one of the learned judge has retired and the other judge, no, it can be cured because it is a vacancy will not vitiate the hearing. Hearing is a composite act by 2, and I have referred that judgment, my lord, that that judgment is illustrated, my lord. Kindly see that part of Jindal, my lord, where the reasoning has been given, my lord, for in compilation number 2, serial number 8, my lord. Sorry, this is the part of, my lord,
Number 7. Number 8, yes.
7.
2, 3, 4.
7.
Because from the commission side, they've given the same judgment.
Yes, my lord.
But paras from commission side, they said 6, 10, and 11. You can 17, 18, 19.
Yeah, my lord, if your lordship will kindly see 17, 18, 19 at serial number 8 of my second volume, my lord.
$240, $334. Yes.
This Jindal judgment, my lord. Aditya,
Yes.
please that judgment because
Yes, the argument or opinion, yes.
(17) is at page 243.
Yes, we got it.
That's the argument that the opinion of the third member in the present case who retired before the order could be signed would not have been material at all for the reason that the impugned order is signed by the majority of the members of the commission who had heard the matter is devoid of any force. It is for the reason that even the dissenting opinion by a member shall have to form part of the final order of the commission in view of the above noted regulation 22 and shall have to be available for inspection, etc. Further, such an order cannot be treated to be outcome of joint deliberations of all the members of the commission who heard the matter. It is often seen that the members of a commission come to the joint deliberations over a matter with their own view which they put forward before the other members, and sometimes even the majority of the members having a contrary view get convinced with the reasoning put forward by the member in minority, and minority view becomes the final order of the commission or the tribunal. In the instant case also, the third member of the commission, if consulted during the joint deliberations, had he been still in service at the time of preparation of the order, he may have convinced. Yes. So it's a very seminal purpose that all members have to sign the order, and it is a composite act which the learned senior was trying to canvass, that it's a composite act of the let's say milords of the division bench when it is hearing the matter, and that is the one which hears the matter, and therefore it has to decide finally.
At 93, my lord, I supplement 93, which has been resorted to and invoked repeatedly, my lord.
Yes, only that point, actually,
yes, my lord. And 93, my lord, if your lordship will see in Jindal only, 93 has been dealt extensively. In Jindal, that read out, Aditya, that paragraph also, that in Jindal judgment, I'm sorry, I'm not having before me right now, my lord, but in Jindal judgment, this aspect has also been dealt in the paragraph, if your lordship will kindly see. Jindal judgment once again. Yes,
Yeah, para 18.
18.
Yes, my lord.
19.
18, 19.
Yes. Now, if your lordship will see, because para 18, what section 92 3 of the
para 18, 92 3 and para 19 deals with 93.
Yes, 19, my lord. Reference made by the learned counsel for the respondent to section 93 of Electricity Act is also absolutely misplaced. The section has already been produced in para 9 here and above. Bare perusal of the said legal provision would clearly reveal that vacancy and defect in the constitution of commission mentioned in the same relate to time when the matter was being heard by commission, that is at the time of constituting the bench to hear the matter. As per said section 93, if there had been any vacancy in the commission at the time of hearing the matter, or there had been any other defect in the constitutional commission to hear the matter, same cannot be made a ground to question the order passed by such bench of the commission. Manifestly, this cannot be made applicable to a situation where there was no vacancy or defect in the constitution of the commission at the time of hearing, but vacancy arose subsequent to completion of the hearing. What more I need? This has not been at all adverted to by learned senior counsel, because he knows that he can't argue this, Lord.
We are against the Jindal judgment in toto. According to us, it is not.
Doctrine of necessity, my lord. Now, doctrine of necessity, paragraph 20, invoked by the learned senior counsel, first respondent in concern, it has no application to the case. The doctrine is applicable to the situation explained by the Honorable Supreme Court in Election Commission of India, where there is an imputation or implied bias to a member of bench hearing the matter, but there is no other alternative. A matter has to be heard and decided by concerned bench. This is amply clear from para 15-16, my lord. So therefore, my lord, there is no doubt that, and absolutely no iota of doubt, that section 93 has no application to a case where matter has been heard by two and decided by one.
Yes.
And therefore, my lord, to say that the judgment of the Honorable Supreme Court in those cases, including in Gullapalli, and in fact, I have referred to, my lord, 3-4 judgments on this point. This is completely unarguable, my lord. I would say to that extent.
I think, they would have had no problem if the order had been recalled and the same had been replicated by the next chairman and by the member.
Oh, yes,
but the whole grievance arose because, there was a total turnaround, and so the fortunes have changed, and so that is why. So that is the main thing. These things are not arisen at all.
I admitted that, my lord. I said so. That's true. These are the realities of life.
So that is
for nothing but would not come to the court.
This entire exercise, you'd have no quarrel, inherent powers. You have no quarrel with, the forum, nothing.
Nobody comes to the court unnecessarily.
Of course.
One is pragmatic. Why should one spend money in coming to court? Obviously, it is only when the shoe pinches.
Very, very, very novel argument. Very novel argument. One more submission, very novel argument that, look, BIA has filed separate petition and I am a separate entity. I have no business with BIA.
Not only that one aspect I still have to really examine it, because regarding the overlapping and whether forget about constructive res judicata. I mean, you're not going to take it there, but the thing is that whether you can on two fronts, you can
this is abuse of process of law, nothing but it's abuse of process.
Only thing is that only the one thing which that still is running the mind with regard to that your answer to whether same cause of action is the same proceeding, you come under another avatar and come.
No, I'm not in that avatar. That's an organization.
That is what.
That's an umbrella organization. Fine. We have no concern with that. So what? How does it matter? My individual right can't be taken away. Can't be extinguished.
If I take this plea, I take this argument.
There is no authority on that, my lord. My rights can't be taken away. The principle of res judicata, constructive res judicata doesn't apply there. No, Dario.
I'm sorry to say. I will approach through association. I will seek relief through association. And then thereafter, if I don't succeed through association, I will individually agitate the issue, my lord. It is, what is this? This is nothing but abuse of process of law.
There is no failure, my lord. The matter is pending. Where is the failure? Had the case of association been decided one way or the other, and thereafter I had filed the writ petition, then question would have arisen. That situation hasn't come. Their constructive res judicata arises. Their res judicata arises. That is not a case.
We'll examine that, but I think that, but you have a point there. If it had been decided, yes, because there are judgments that says that once you come under a, yes.
Lord, there is no judgment contrary to my action.
I asked myself, whether the association is representing me or not. It is association is representing. No, but association is representing, association has canvassed and association has not taken up the second objection. And now I want to take it individually.
That order was not there at that point of time. That order came subsequently. I have spoken about the cause of action, the totality of the cause of action.
Your arguments on this, on collective individual. Okay, we noted that anyway, yes. Only that is still playing in the court's mind. That's all. That's all. Playing the court's mind.
I'll give bullet points on that.
Yeah, right. It's not decided. Yeah, right. But then it's still playing the.
Third page of my submission, my lord. Third page of submission. This is abuse, my lord. It will come under the category of abuse. See, you must first approach the equitable court with clean hands. And why have you not approached? Because I have approached through this court, through association. I wanted to get the order of recall set aside, and then I wanted, and that association has not challenged consequential order. Now I am challenging both orders, recall order and consequential order, my lord. That because my rights are getting affected, my lord. This is not the way to approach the equitable relief, my lord. This is my submission, and if your lordship will see my page serial number 3, my lord. Serial number, page number 3 of my note.
Yes. Suppression.
Suppression of previously now individual members. Memorandum of Association of Burnie filed by BA before APTEL through so and so that they are members of this association. And I have given the list, my lord, and I have relied on these judgments, my lord. I need not trouble your lordship with judgment at D, E, F, and G, my lord. Your lordship kindly take note of these judgments.
Yes.
Because on this ground also the petition should have been thrown out, because you go to the court, you should go to the court with the, because now they are arguing it's not res judicata, because the rest, it is neither res judicata nor res sub judice. Because there is no decision between the parties, therefore all members can individually keep on filing the petitions.
That's what I'm saying, that is still playing the mind of the court, this aspect, yes.
And my lord, previous order, now serial number 2 of my notes of this court is dated so and so. So my lord, I have covered.
Yes.
The court is the commission is not court or tribunal. First is what was the argument that the order passed by the commission was without jurisdiction. That aspect I have shown, my lord, it is within the jurisdiction. It was considered also. Later on, change of mind, change of heart, change of PA, because of my argument that your lordship will take note of that. The second is that they are saying that it is a limited judicial, my lord. That I have shown that it is inherent in them. If you have passed the order in a non-est order, can be recalled. For that I have already said, my lord. Now I have already referred to paragraph 6, the section 66(5), which gives certain powers to the commission to even revoke or amend the tariff order, my lord. Then, my lord, section 111 are wide enough expression under any order, my lord. Any order will give the remedy of appeal to the appellate authority. And, my lord, these are my submissions, my lord, and your lordship will certainly take note of the fact that if the change of heart has taken place on account of my objection, that
no, we've noted
error.
Yes.
So that I raised my argument, you know.
Mr. Venkatesh, anything to add to the arguments?
Yes, just one point to add, Millards.
Yes.
For my lord's consideration, because your lordships, my lords, are effectively going to decide this question of interplay between 92 and 93. As my lords, my esteemed senior from the petitioner side pointed out to your lordships that there is no judgment which today occupies the field which says that a quorum which hears the matter if there is a vacancy in that quorum, still the order can be passed. I think what my esteemed senior is relying upon section 93 to press his submission, and 93 would protect such a proceeding, such a course. And even if a person demits office, the commission can proceed and pass an order. The first principle of law, Millers, as I understand, is that every proposition should be taken to its extreme and then tested. Otherwise, Millers, it may not make sense. Now, the proposition which they canvass right now is that, please appreciate a situation, Millers, where kindly have a look at section 92 for a minute, and I'll make that point very in brief minutes.
I remember it.
In fact, Millers, to test the proposition of my esteemed friends, Millers, from the petitioner side, my learned friend, Millers, kindly look at section 92, subclause 3.
Yes.
All questions which come up before the meeting of the appropriate commission shall be decided by majority votes of the members present and voting, and in the event of equality of votes, the chairperson or in his absence, the person presiding shall have a second or casting vote. Now, my lords, if this argument is to be accepted, then effectively a case of a two-member commission where the third member has not been appointed, the two members are having a view of divergence. The chairperson feels one particular course of action, the junior member feels another course of action. Now, it so happens that the chairperson is due to demit office because of his date of appointment. If this interpretation of 93 is to be accepted, then the only thing that is required to be done to negate the casting vote of a chairperson is waiting for him to demit the office. Now, is that what the Parliament intended when it framed the Electricity Act by making a multi-member body? My respectful submission would be the answer is no. And I say that for two reasons. Now, my friends from the petitioner's side very summarily have rejected the Commission's own regulations by saying the regulations effectively defeat the object of section 93, therefore the regulations are not to be looked at. Now, my regulations are quoted by us in our pleadings and in fact quoted in the impugn order as well, and it reads that all orders of the Commission shall be signed and dated by the chairperson members hearing the matter and shall not be altered except to correct any apparent error. This regulation has not been adverted to. That the Commission is bound by this regulation has not been adverted to. What is being said is that I don't need to challenge these regulations, but ostensibly this regulation violates section 93, so kindly ignore. And they're asking your lordships to ignore this and decide the matter, dehorse the regulations. But in my respectful and humble submission, if my lords would look at 92 and 93 again, the scheme operates in two different fields. 92, my lords, more particularly 92.1 says, the appropriate commission shall meet at the head office or any other place at such time as the chairperson may direct, and shall observe, kindly mark this, my lords, such rules of procedure in regard to the transaction of business at its meetings. Now, my lords, this rule of transaction of business is what I read out to my lordship, your lordships earlier, which is being sought to be ignored. So the Parliament intended we will self-regulate. We self-regulate, following, my lords, a very established principle of natural justice that yes, those who should hear should decide the matter. We follow the same very principle. But my lord, the argument seems to be that even though the Parliament wanted you to self-regulate, you have rightly self-regulated. I could have understood a case where the Commission frames the regulation to the converse. Since irrespective of who hears the matter, those who is present at the date of signing shall sign the order. That would defeat, my lords, the principle of law which is now accepted since 1959, natural justice. That, my lords, if a three-member body is sitting together, even the person which has a divergent view has the right and, my lords, the duty to convince his other members to come to a conclusion which he thinks is right. All that, my lord, would be laid to waste if this interpretation is to be accepted. That's point number one. Point number two, my lords, and of course, the learned Advocate General has already touched upon it by showing to your lordships how the tribunal in its interprets section 93. 93, my lords, in my respectful and humble submission, only talks about existence of vacancy to invalidate proceedings or defect in constitution of the Commission. If this does not, and the Constitution itself is, my lord, section 84. I read to your lordships last time, not reading it again. But this does not in any way, 93, my lords, cannot in any way be interpreted to mean that irrespective of who hears the matter, what is the composition, the order can be signed by any one of them. That will not would again do violence to what I said, what the example which I cited earlier, because ultimately your lordships, as the Honorable High Court will test this proposition
And whatever your law, your lordship lays down will have to be taken to its most illogical end to see whether the proposition fits or not. Therefore, my lords, the only thing that really comes to play in a given case when there is, my lords, a vacancy at the commission level is at best a procedure has to be followed. But the moment the procedure gets followed again, in fact, a hearing is given, an opportunity is given to both sides to make their argument, then only thing, my lords, that we are sacrificing right now is time. But the propriety of decision making, the process of decision making, and its result are not in question. Yes, it will take some extra time, but that's the end of the matter. My lords are dealing with a statutory body. Therefore, my lords, whichever way your lordship decides, in my respectful submission, this will be a strong guidance. I don't want, my endeavor as commission is only to say this much, that whichever way my lords will take this view in the matter, take a view of this matter, at least the recall order, it should not be that the 93 power, which is limited to protecting the validity of the commission in case of vacancy, is used to an extreme end to violate the principle of natural justice. Or, my lords, all of this takes place in the garb of 93, which according to me, my lords, should not happen. That's, my lords, my submission on section 92 and 93. And they operate in very different spheres. The rules that we have are framed under 92, not subject matter of challenge, not subject matter of discourse today. Parliament intended us to do so, and we've done that. And according to me, my lord, the rules that we have framed is in consonance with the settled principle of law that those who hear must decide. And in this case, there were two members who heard the matter, and therefore the order, according to me, should have been passed by the members concerned, or a fresh opportunity would have been given to everybody to make their submissions, which would include, my lords, my friends on the petitioner side and my friends on the respondent side. That's, my lords, on this point. Last, my lords, I had referred, my lords, to the Waqf Board judgment only to, my lords, emphasize one issue. That is, similar provision under the Waqf Act has been interpreted to mean what? It has been interpreted to mean only in case of vacancy can a section 93 or section 22 of the Waqf Act would come into play to protect the commission and its actions taken therein. It does not, my lords, decide. Therefore, my lords, in fact, my esteemed senior was very fair to say that no judgment could he lay his hands on. In fact, my lords, even we have not laid our hands on, which says that 92, section 22 of the Waqf Act or 93 of the Electricity Act are to be used to protect proceedings or protect infraction infirmities, the nature of which is seen in this particular case, which is two here and one passes the order. That is not the point. Nobody, my lords, has cited a law to your lordships to show that this is also permissible by virtue of extending section 93 or a similar provision and another similar parliamentary enactment. Therefore, my lords, I would respectfully submit, Waqf Act was very clear. It only, my lord, lays emphasis that this is for the purposes of protecting proceedings or quorum during vacancy. That's about it. Nothing more, nothing else.
Okay.
Last point, my lords, in addition to what has been argued, my lords, by my esteemed friends and my senior, my lords, and I'll put this in my bullet points, my lords, is that as a statutory body, my lords, we under the parliamentary enactment have been given the power to frame our regulations. The moment we frame these regulations, we get bound by it. And accordingly, my lords, anybody who appears before us is also bound by it, subject to, of course, challenge in an appropriate case, my lords. Here, my lords, the regulations framed with categorically provide for a particular process of adjudication, and that process, my lord, binds all of us as long as the regulation is not interdicted. That's the statute, that's the mandate of law in terms of PTC versus CARC, my lords, and therefore I would respectfully submit, my lords, the Commission in recalling has rightly exercised jurisdiction, my lord, because the order did suffer from an infraction which went to the very root of the matter. And lastly, my lord, my learned Advocate General has also alluded to in his submissions the judgment of the Honorable Supreme Court in Noida, my lord, in the Noida matter, which we both relied upon, that has been brushed aside by petitioners to say deals with tribunal. In fact, it dealt with the powers of National Company Law Tribunal, which is a statutory body created under the Companies Act, governed by the rules framed by the central government, which is parametric to our case because we are also a statutory body created by a parliamentary enactment. Only difference is because electricity is a concurrent subject, the central government does not frame rules for our conduct of business, we ourselves frame our regulations. That's the only difference. But in law, my lord, the judgment only dealt with that such bodies, if they have inherent power in their regulations, because they anyways do, in terms of how they are supposed to act and conduct their business, therefore those inherent powers are protected. Therefore, my lord, true, merely because the nomenclature for NCLT is a tribunal, whereas for us it's a commission, would really not make a difference because both are under a parliamentary act as framed by the parliament. That's my submission. I'll put it in a 1 or 2 page note, minutes to provide it. I'm so grateful.
Only one thing, Mr. Thapa. Where's Mr. Thapa? You'll make submissions. What is the situation now? Is the court
matter is already heard in length. The only thing, I have a very limited instruction, like I said earlier, we would like to supplement to whatever.
Can you just give some bullet points, something? You prepare in conjunction with Mr. Paul, and then
I don't know, Mr. Paul.
Because you see, the thing is that this matter's got some urgency also. We understand his problems, We have like extreme sympathy for that. The thing is that
his entire bereavement is
1 month.
Getting over on 16th.
No, because it's not a question of not being heard. Because the thing is that it's been substantially heard. I mean, all the points have been covered. Only if he has, if you can fill him in anything he wants to add, that's all. But when will he do it? That's the only thing. Because now we're already on the third, and if.
In fact, I have a request, if it can be on 18th. 16th is the last day. We are having.
Mr. Thapa has filed the case. He has got the stay. He argued the matter, and Milord, there was a clear and unequivocal.
There are arrangements being made. Yes.
Yes, Milord, and clear understanding, Milord, that he will make the alternative arrangement, Milord. Otherwise, I will lose 125 crore rupees of RDSS, and I will have higher interest also. RDSS scheme, central government is not going to pay me this 125 crore because they are enjoying this stay. Because of that, I am not able to recover the money, Milord. And if there is no recovery, there is a penalty by central government under RDSS scheme. And this is the tariff policy which is they have accepted as on today. It is a valid. There is no stay on the tariff policy, Milord. And everybody has argued. Mr. Thapa has also last.
I think what else can you add to the arguments? What else is there? All the ground. Mr. Tiwari has gone. He's
also considered reserving the judgment in other matters, keeping that one for the hearing. Other judgments matter to be reserved.
Serious argument would also cover what Mr. Paul would like to submit.
Depending on the pleadings you made in your petitions. Points of law has been covered by Mr. Tiwari inadequately. Everything, with regard to.
I would again reiterate my prayer for 18, Malot. In the meantime, parties can file their bullet points. We will also be ready.
Then we vacate interim order. They won't continue.
Our case stands on its own footing. In their case is different. They may be association. We are not. We are for enforcement of our individual right.
Your association appearing how many other parties
will not give money to me.
Yes.
Interim order is operative only in item number 11, 12 and 13 as far as I know.
Ours is 12 and 13.
This court is left
13 and 14. Under new bills, they have included the area payment which was stayed by this honorable court.
Current we are paying in any case.
Current we are paying. The tariff order which they are saying, current bills are being paid. It's only the area payments that are stayed. It's not the bills are not being stayed. This is a wrong submission which has been made. It's not that we are not paying the bills as per the tariff order dated 24.
Tariff order includes both payment of areas as well as and there is no
retrospective part. They have not submitted anything as such. Why cannot be retrospective?
Lordship knows it.
So that is. So we are
tariff order is there because of 23rd August order. Had there been no 23rd August order, there would have been no tariff order.
64(6) helps on this account.
It's okay.
What to do about the deadlock with regard to
heard the matter to reserve the judgment, my lord, we will file our written notes, bullet points.
Only thing is if your lordship go on to pass an order, my lord.
And my friend will also file it, my lord.
We do not know what Mr. Paul would submit. My lord, again, without hearing whatever, maybe our submission would be similar to them.
You consult them today. We'll post it tomorrow the matter and come up with instructions.
Difficulties, my lord, I have not been able to speak to him, my lord. That is the problem.
Could I take a request, subject to what your lordship would find? Yes. Where Mrs. my esteemed senior is appearing on the petitioner side, those matters your lordship can reserve, because of course your lordship will take some time to decide all of this as well, and have the BIA hearing step. There's no interim order in the BIA matter.
No interim order, yes, true. That's an association, my lord. We are individuals. We have stakes. Association loses nothing. Individuals lose.
Helps your case.
It does. It does. In any case, Lord, I am not on a slippery wicket on this ground. I am not. Individual rights can't be extinguished. On the lighter note, Lord, I recall, Lordship may recall possibly, we used to joke. I remember SS Day, the former Advocate General of Tripura. He has coined a new term called res advocata. From res judicata, he would say, a lawyer making X submission on day 1 could not have made Y submission on day 2.
And you know,
that is
SSD on a very high stakes matter regarding Manipur defection.
I know.
And when he was led by Mr. Amazondar, we were on the other side, and he came as he withdrew those writ petitions challenging the tribunal's order before the single judge. And then later on, with intent to file again, we didn't take liberty. And so when he filed it again, then we took that, defense.
That is constructive res judicata.
No, that's what. And so, we had withdrawn him with liberty actually, but just, he forgot to say it. And the career of around 3-4 legislators
very big.
The repercussions were so huge. Whether it was Supreme Court, but then
that is principle number 1, my lord. I was taught by my senior.
Junior counsel, but then
never withdraw a writ petition without liberty. First principle. And second principle, my lord, I learned from late Mr. Azam Lahiri. I was badly rebuked. I remember during my junior days, I carried one judgment to him and showed one paragraph. He just went through for 5-6 minutes and then he started rebuking me. Don't show me a paragraph in future.
Exactly. Yes. Read the whole.
He was very particular.
Yes. So, any what to do with the? So, we'll hear the BIA matter only on 18th.
I think
we'll reserve the other matters for judgment. You're appearing which other matters?
13 and 14 is our matter.
12 to 19.
No, 12, 13 and 14 is our.
13 and 14.
12, 15 to 19.
No, sir, in fact, in majority of the matters, Mr. Paul is appearing.
Anyway, I am concerned with my cases, so 13 and 14.
13 and 14.
That's all. I am not concerned with the rest.
So, item 13 and 14 has been heard, has been reserved. Items number 12 to 12, 15. Lead matter is 42. 43, sorry. Item 43, connected with, you'll be hearing together, you're going to segregate 43 to hear separately. Item 43, 12, 15. This is getting a slight problem. 16 to
19. Stay has to be vacated so far as the other matters are concerned.
How could it be? How could stay be vacated in 13 and 14?
Not appearing in that matter.
Oh, very well, very well. So I thought, sorry, I thought about my case. You are making a submission. It's okay. So sorry.
No, you just come with instructions tomorrow. We won't list it, but we'll pass orders. But 13, 14, I'll reserve for judgment. In the other matter, I'll just won't write order today. Just come with instructions.
Milord, 13, 14, only one prayer, Milord. In the intervening period, Milord, no coercive measure. Current bill we will pay. We are paying continuously. Only that much, Milord, there is a worry. And there is a serious threat.
Interim order is like Lordship for the first.
Yes, why are you so worried?
Lordship may kindly make it operational till the intervening period.
Tomorrow. You can just consult my PS. And
because there may be disconnection. At least there is no commitment to that effect. So we are worried about the coercive measure. In the intervening period, that observation will not may kindly be. Very well, very well. Very well.
Obliged.
Obliged, so grateful.
Speaks for the